Be seated, please. All right, the first case we're going to hear this morning is CPI versus Vivint Smart Homes, and Ms. Thompson, we'll hear from you.
Thank you, Your Honor. Elodie Thompson, Quinn Emanuel, Urquhart, and Sullivan on behalf of Vivint. The $189.7 million jury verdict in this case is unsupported by sufficient evidence or the law. Nothing in the record can justify this windfall to CPI, and at a minimum, this court should grant a new trial based on the verdict being against the great weight of the evidence. But let me start with the clear legal issues. First and foremost, the district court erred as a matter of law in not granting judgment to not granting judgment to Vivint on CPI's UDTPA claim. That's because North Carolina law makes clear that a plaintiff bringing a UDTPA claim must assert first-party reliance if it is based on a misrepresentation theory.
Well, you know, I understand your argument. You made it below and you made it above, and I don't think it fits anything. If it's based on fraud, the fraud in this case was committed against CPI customers, not against CPI. And so CPI wouldn't be the reliant. The fraud that's discussed is the fraudulent statements made to the customers. And the customers did rely because the allegation is they changed. Now, I don't understand your argument that CPI has to rely on it because the fraudulent statement wasn't made to CPI. My suggestion is you go on to your tougher issues. I see, I'm speaking for myself, I see nothing to that. But
Yes, Your Honor, just briefly. So in the North Carolina Supreme Court's decision in the Bumpers case, there were underlying claims brought by parties who did not have first-party reliance, just like CPI here.
I know, but they were fraud claims, directly claimed. CPI doesn't claim it was defrauded.
So
it claims unfair competition because its customers are defrauded.
Yes,
and it seems to me it's basic Hornbook law that when there's a misrepresentation, somebody has to rely. But North Carolina's not off base on this. If the case is a fraudulent claim based on the plaintiff relying, there has to be reliance. But this claim is not a claim that CPI was defrauded. This claim is unfair competition because false statements were made to CPI's customers, and the customers relied. Isn't that the argument? That's their argument, isn't it?
Yes, Your Honor, that is CPI's argument. But in the Bumpers case and in the D.C. Custom Freight case from the North Carolina Court of Appeals, neither of those were fraud claims. In the Bumpers case, it was an overcharging case under the North Carolina statute.
This case involves unfair competition, right?
Yes, Your Honor.
All right. You can continue.
Sure. Just briefly, I want to address the unfair competition point, and then I'm happy to move on. On the unfair competition point here, unfair competition was solely based on misrepresentations. That's because in the jury instructions, the court instructed the jury to find liability on the unfair competition claim based on 8 misrepresentations or types of misrepresentations that CPI asserted. This is at Joint Appendix page 1859. Listing the basis for the unfair competition claim. So even if a broad unfair competition claim that didn't specify the basis—
What were the statements made? The statements made were statements made by Vivint sales representatives to CPI customers, right?
Yes, Your Honor.
Okay. Those fraudulent statements, false statements were made to CPI customers. The law in North Carolina and everywhere else in the United States says that those customers had to rely on it to make it actionable. And the question is, there's no argument that the customers didn't rely on the false statements. Some customers changed because of the false statements.
Well, let me address that point briefly because
you can address all of this. You can go on for a while, but I'm suggesting that
sure.
You're kicking a dead horse.
Understood, Your Honor. Just 2 very quick points. One is that the Court of Appeals decision in D.C. Custom Freight expressly says, quote, "The holding in Bumpers precludes a UDTP claim such that, as in Ellis, in which a third party's reliance caused damage to the plaintiff," end quote. So the North Carolina Court of Appeals has specifically said there can be no UDTPA claim when it's based on third party reliance. unless there is persuasive data that the North Carolina Supreme Court would hold otherwise, then this court is bound to follow that.
But doesn't the statute go back and discuss tortious interference? I understand what you're referring to, like the first part of the statute, but there's a second part of the statute discusses tortious interference, which the jury in this case found that there was tortious interference with the contract.
Yes, Your Honor. Certainly, the jury found tortious interference with 7 customer contracts. I don't know how that gets to $29.3 million in damages on the UDTPA claim, but the tortious interference claims, this is on pages 8 to 9 of the reply brief, the carryover page. All of those customers testified that it was a misrepresentation. It's not as if there was some allegation here that...
What about Miss Joyce Mauricio, I think it's Mauricio, who testified that the Vivint representative did a credit check on her daughter and then ran the daughter's credit without the daughter's permission, and then Vivint representative sold her equipment without informing her that it would be taking out a loan from another company. Is that misrepresentation or deception?
Well, Your Honor, that's not any injury caused to CPI. There's no claim, because there's no interaction between.
The fraudulent statements made to the customers cause CPI to lose customers, and they're damaged by that. To me, this is a straightforward deceptive practices claim. You're trying to piece together claims that are clearly, if a statement is made to one person and another person brings the action, the other person can't claim it because it didn't rely on it. Your argument is that CPI didn't rely on any false statements. But the whole theory of the case does not involve false statements made to CPI.
That's absolutely correct, Your Honor. It involves false statements made to customers. And one of the reasons for the first-party reliance is because here CPI is claiming that thousands of customers were induced to switch to Vivint from CPI.
That's a claim.
But there is no support in the record for that. There is no support for even the 565 customers that they say were subject to deceptive trade practices. That's all hearsay. That's all a spreadsheet. There's no foundation for that number. But even then, we go to the 20x multiplier that they used. And that 20x multiplier, there's no basis in the record for it to be anything but speculative.
As I understand it, the 2 experts testified that based on their data and research, 5% of the people complain about problems. And the question is, they had numbers 4.6 to 6 or whatever, but that was their research. And they would say, this is nothing untypical about this one, that they conclude, in their opinion, that only 5% of the people actually made claims. Other people just live with it or go on with it. That's their argument. Now, if their research is flawed, social research, you can address that, but that's the basis for their making that statement, right?
First, Your Honor, they did not make that statement. And you don't have to take my word for it. You can go to the record.
What did they make then? They said that 5% of the people traditionally complain and the other 95 don't, right?
That is not, Your Honor, what the expert said, no. And I would point the court to Joint Appendix page 1101 to 1102, where CPI's own marketing expert, Dr. Weinert, admitted there is no generally accepted multiplier in either the industry or academic literature. If you look at one page, look at Joint Appendix page 1024.
Don't you have to look at what the expert says and what they based it on?
Yeah, Your Honor, I think what both of the experts testified is that there's no way to quantify a multiplier. What CPI could have done is say, based on the evidence we have here, here's what the percentage we think of CPI customers who complained is, and therefore use that. That's not in the record anywhere. Nothing links this multiplier specifically to CPI customers complaining. And in fact, if you could go to Appendix page 1024, Dr. Weiner testified the estimated rate of customers who complain is a, quote, bit across the map. That cannot be sufficient under this court's case law or North Carolina law to support a damages verdict based on a totally speculative multiplier.
Well, let me ask you about that. The parties elected to have general verdicts on the 4 claims. And the $29 million verdict either involves damages to CPI or disgorgement from Vivint, right? And we don't know what combination of those two the verdict 29 million represents, right?
Well, we don't know exactly what the $29.3 million verdict represents. That's
Okay.
absolutely
No, my
correct.
question is, it includes one of two components, and this was argued to the jury by either disgorgement or damages or both, but not duplicative. They were instructed not to duplicate, right?
So, Your Honor, both parties requested that the jury be instructed not to award duplicative damages. Yes,
Right.
that is
Okay,
correct.
so now the question is, we have to assume on a general verdict, we have to assume that the jury did either or one or the other or both. And as you know, disgorgement is not a damage claim. Disgorgement doesn't depend on damage. Doesn't have to be any damage to have disgorgement. It's an equitable remedy that requires Vivint to disgorge its ill-gotten gains. Damages to CPI is a damage claim based on lost profit to it. How do we assess a general verdict in this case under any argument? I think if we knew what portion was disgorgement and which portion was compensatory damage, there could be an argument that we shouldn't be including the disgorgement, for instance, in the punitive damage assessment and so forth. But we don't have that information. We have a general verdict.
Sure. Well, let me just briefly address a couple issues that I think Your Honor's question raises. And one is the duplicative damages between, on the one hand, the UDTPA claim, and on the other hand, the three underlying claim. Now, North
Well, let's
Carolina...
stay away from that. I'd like you to stick just, well, go ahead. That's your argument.
Yeah, well, I was just going to say, Your Honor, that North Carolina law is clear that you can't recover both the UDTPA damages and damages for the three underlying claims. You may either elect to treble the UDTPA damages, or you may recover the underlying claims, the damages on those claims, with punitive damages for those that are eligible.
Well, it depends how the jury's instructed on the claim. They were told to award lost profits to CPI, or on the, this is on the state claim, or disgorgement. You both argued for allowing disgorgement. It's a strange remedy, as you know. But they carved out in awarding the jury how much marketing expense they incurred that was useless, and made that a separate category claim. And how much, in other words, each of those other claims, the jury was told to carve those out, right?
Well,
And not
again,
duplicate.
we don't know what the jury did in terms of assessing those, but what we do know is that there's a lack of sufficient evidence supporting those damages in the record, and we know that the district court...
Let's assume you're right, and the jury said, they're back in the conference room, and they're sitting there saying, under the, one of these claims, and they say, well, CPI didn't prove damages adequately, we don't think, but we do believe that Vivint gained profits from its ill-gotten profits, and we're going to disgorge our whole verdict disgorgement. How do you address that? Disgorgement's equitable. You don't need to show the detail that you do.
Again, there is an election of remedies required under North Carolina law, and in fact, CPI was aware of the need to make that election
It's not an election of
post-verdict.
remedies. You can have both. Disgorgement is not a damage.
Well,
CPI
again,
and damage, I mean, your brief is just totally off on the notion of disgorgement. You accept the fact that the jury was asked to award disgorgement, but then you, instead of carving that out in a form, you agreed to a form for a general verdict.
well, again, Your Honor, there were damages awarded for each claim, which makes sense because you have to have damages attributable to each claim. But here,
Not
the
for
jury
disgorgement.
was told, and that's page 1703 to 17, excuse me, the CPI requested that the jury find liability on the UDTPA claim if the jury found liability on any of the other three claims. And in fact, that is what the jury was instructed. So the jury had to find liability on the UDTPA claim based on the underlying claim, which means that the verdict form indicated that UDTPA damages, there was a line for that, for trebling, and the other claims were compensatory damages for those claims subject to punitive damages. And let me just address punitive damages very briefly, which is that North Carolina law is clear that the UDTPA damages cannot be included in the cap for calculating damages under North Carolina's punitive damages cap, and that is the Pinehurst case, which specifically says that punitive damages may not be awarded for a UDTPA claim absent legislative intent. That case is a 1986 North Carolina Court of Appeals case. That was 40 years ago, and there is no legislative indication that the UDTPA claim should be incorporated into the calculation for the cap on punitive damages. Thank you.
Okay, is that it? You'll be back on rebuttal.
Yes, sir.
All right, Mr. Wall, good morning.
Good morning, Judge Niemeyer, and may it please the court. The jury heard extensive evidence of Vivint's misconduct, that it trained its employees to bully their way into homes, to mislead or lie to customers about their affiliation with CPI, and to persuade those customers to switch services under false pretenses. Faced with that evidence, the jury did exactly as it was instructed. It awarded a distinct amount on each of the 4 claims for a total compensatory award that was less than what CPI had asked for, but more than Vivint urged. The jury also awarded punitive damages within North Carolina's 3-to-1 cap. Judge Cogburn then rejected Vivint's many arguments against the verdict in a thorough post-trial opinion, just as Judge Whitney had rejected them at summary judgment. There is no error in this verdict, and we respectfully ask the court to affirm and welcome the court's questions. They have only one issue that is subject to de novo review and does not, involve deference to the jury or to the trial court's evidentiary rulings. That's the UDPA issue. It is the case in every state in this nation that if I walk up to a customer's door and I lie to them about who I'm with, that is a deceptive trade practice. What the other side has done is they have plucked a case out of context from a decision of the North Carolina Supreme Court called Bumpers. And in Bumpers, you had customers who were saying, I was lied to by my bank about my account. And the North Carolina Supreme Court said, well, wait a minute. You didn't shop around for the loans. You didn't look at the loan agreement. If you are going to claim that the bank lied to you, you have to show reliance. Because, of course, for a fraud or a misrepresentation claim, if you are claiming you're the one that got lied to, you have to show detrimental reliance. That's at page 89 of Bumpers. What the other side has done is they pulled that case out and they've said, aha, we have a misrepresentation case, hence you have to show first-party reliance, and you don't have it here. The North Carolina Supreme Court in Bumpers was not cutting out the entire class of deceptive and trade practice claims in which instead of lying to your competitor, you lie to their customers or their suppliers or their vendors. Yes, someone has to detrimentally rely. If it's a fraud claim, you have to detrimentally rely. If it's a tortious interference or unfair competition or trademark infringement claim, the customers or the suppliers or the vendors have to rely. North Carolina Supreme Court wasn't trying to overrule the line of its decisions that allow these kinds of claims under UDPA, and they weren't in any way touching this court's cases. Cases like Belk, cases like variety stores that recognize a garden variety deceptive trade practice claim. I go and I tortiously interfere with your customers. That's their only legal issue. Now, I will say...
Let me ask you the question they raised right at the end. She said that you can't award punitive damages on a deceptive practices claim.
So that's not right, Judge Niemeyer. There were by everybody's accounting here, there were 2 claims that were subject to punitive damages. The 2 common law claims, unfair competition and tortious interference. Nobody disputes that those are eligible for punitive damages. We think there's a 3rd claim that was eligible for punitive damages, the UDPA claim. They disagree. But either way, the jury awards $140 million in punitive damages, and it's not asked to assign that to any particular claim. That's their verdict form. We didn't like it, but it was their verdict form, and the judge took it. At that point, the only thing that steps in is the North Carolina statute. If it's within 3-to-1, the punitive damages award is fine. I will say, though, I think the Southwood case is good on this, that if you have an UDPA claim and you don't treble, that untroubled UDPA claim is eligible for punitive damages. Now, you can't do both. You can't treble.
Is there a concept of election?
Well, yes. The plaintiff can either elect to treble or can elect to have punitive damages on the UDPA claim. Now, here, because it's a 3-to-1 cap, it doesn't really make much difference. If you sent the case back and we trebled the UDPA claim, you'd come out to almost exactly the same. You'd be at 177 instead of 189. But the point is, we didn't treble on the UDPA claim. So, but my more basic point, Judge Niemeyer, is I don't think it's right to say punitive damages were awarded on that claim. The jury had claims in front of them that were eligible for punitives, the common law claims. Nobody disputes that. They award punitive damages.
But they did allocate the damages among the four claims.
That's right. On compensatories, they allocated among the four claims. That's right.
And so the guide for punitives was multiple of all four claims, and one of them was the unfair competition claim, right? A statutory claim.
That's right. So you have some punitive eligible claims, and you get a punitive award. And then what the North Carolina statute says is, you take the amount of compensatories, you look at the amount of punitives, and you ask whether the amount of punitives in the action is more than 3 to 1. And here, you add up the compensatories, you add up the punitives, they're within the 3 to 1 cap.
My biggest trouble, these damages are quite large. My biggest trouble is if disgorgement was awarded and it had been allocated on the form, I'm not sure disgorgement would have given rise to punitive damages. It's an equitable remedy. But we don't know what percentage of the verdict, the general verdicts, and is disgorgement and which is actual damages to CPI. I don't know if there's anything to say. I mean, the question is, my question to you would have been, had they allocated one of those elements all to disgorgement, you probably would have excluded the disgorgement from the multiple for the punitives. But
So I think, look, I actually think you could have punitive damages for disgorgement, but that's a sort of interesting legal question. I just don't see how you get at it here. The parties agreed on jury instructions, and no one ever argued that disgorgement wasn't eligible for punitives.
the parties argued at the jury, the court instructed the jury on disgorgement?
Well, I mean, what I'm saying is, there was not a word below that said, Judge, you got to tell the jury they can't award punitives on disgorgement. It is not an argument in the case. Then the jury gets instructed, both sides agree on the instructions. They say nothing about not awarding punitives on disgorgement. Then we have a general verdict form, which they supplied, which doesn't break it out. So for all we know, it's lost profits, it's goodwill, it's corrective advertising. We have no idea whether the jury awarded a single dollar
I
in
think that's
disgorgement.
the best argument you can make, because I think the punitive cap relates to compensatory damages. Punitive damages are authorized on compensatory damages. And I think it's pretty well established that disgorgement is not a damage. You don't have to have any damage to get disgorgement. But the argument is, we don't know what the jury did. We have a general verdict, and it could all be compensatory damages.
So I take that point, Judge Niemeyer. I will add one small thing, which is, I do think in the context of this North Carolina punitive damages cap, when it says add up all the compensatory damages, I think the best reading of that is damages for harm, and it's not separating out between old remedies at law and remedies at equity. It's saying take the non-punitive part of the case and just ask whether the punitive part of the case is more than 3 to 1, because that's kind of rough justice. We'll just say that's a pretty good measure of what you should be able to get. So I don't think the North Carolina statute distinguishes between legal and equitable remedies in that way.
Well,
But
not
I'm
an
happy
equitable
to.
remedy, but disgorgement is not even a damage. CPI doesn't have to prove damages. What they have to prove only is that the conduct led to ill-gotten gains, and you're disgorging Vivint of its ill-gotten gains, its profits. But I say all this, it could be totally hypothetical based on what the record is here, but.
So again, I don't see any way for the court to get out of here. I will say, Judge Niemeyer, I think this is sort of the worst case for that, because here, the testimony in front of the jury, and it wasn't really disputed, was the average account value for a CPI customer was somewhere in the 3,000s, and for Vivint, it was around 4,000. And so they said to the jury, look, just figure out how many customers you think they poached, and then if you want to do the disgorgement, you multiply by 4,000, and if you want to do lost profits, you multiply by 3. So there is some delta here between what you would say is a lost profits measure and a disgorgement measure, but it's not a large delta, and it's not the sort of thing that would have swung a damages award hugely in one direction or the other. I mean, we're talking about at the margins, did they pick 3,500 or did they pick 4,100? Again, we don't know because they weren't instructed in any way to separate, and we have a general verdict form. Now, they want to slice and dice by category, but Robinson says you can't do that because you have a general verdict form. So the only question for this court, I think, that's actually preserved is, was there enough evidence in front of the jury for it to come back with a compensatory damage award of $49 million? And the answer to that is absolutely yes.
All right, what's the basis, your understanding of the basis that was given for the 5% figure on making complaints?
Sure, so if you look at pages 1023 and 1024 of the joint appendix, our expert, Dr. Weiner, who's the deputy marketing chair at the NYU School of Business, he's got a PhD from Carnegie Mellon, he's published about 80 articles on this. He says, look, everybody knows that customers don't complain all the time, right? I had a yard man earlier this week who did a lousy job. I went in and complained to my wife. I didn't call the company. Everybody agreed, both sides, that there is underreporting. The question was, what's the factor? And our expert said, I think 97, 95%. And then we pointed to the fact that in a separate suit where Vivint was the plaintiff, and this is at page 3287 of the joint appendix at footnote 1, we said when Vivint was a plaintiff in one of these cases against an alarm company, it said 25x as a multiplier. It said only 4% of customers complain. So that was our number. They said, we think it's 1 to 2. We think it's more like 1 out of every 2 customers complains. That was a dispute from the experts. Classic question for the jury to resolve. Now, as best I can tell, right, we asked for $77 million in compensatories. They gave us 49. As best I can tell, the jury looked at it and said, we're not sure they poached quite as many customers as you think CPI, and we're not sure the multiplier should be quite as high as you think, but probably closer to yours than theirs, and that's where the jury came out. And that is what juries do all the time when faced with competing testimony from experts. They wanted one multiplier, we wanted another. I will say, based on my own experience, I think ours is a lot better. I don't think 1 out of 2 customers calls and complains, but wherever you think it is, that was a classic fact question for the jury. I will note, Judge Niemeyer, they didn't Daubert the multiplier. Like, that's not here. They're not saying this expert was not qualified to testify, none of this testimony should have been in front of the jury. They're just here saying they think that multiplier is way off. But that's the province of the jury. It gets to decide what it thought the multiplier was, right? And look, that was the key question.
Did they put in evidence of 1 to 2?
They had an expert who was a financial consultant, not a marketing expert, no PhD, all the rest. But he said, look, I think it's more like 1 to 2. And we said, we think it's more like 1 out of 20. And by the way, Vivint, when you were a plaintiff, you thought it was 1 out of 25. And we put all that in front of the jury, and the jury made a decision. And by the way, I think a pretty reasonable decision when you look at it, because there was so much testimony from customers saying, these guys showed up at the house, they acted like they were CPI, they told me CPI was going out of business and all the rest. And a lot of those customers didn't ever call to complain. They didn't know about it until this case came along. So we know that there's underreporting. It's a question of how much. That's a jury question at the end of the day.
Let me ask you about the Lanham Act. Because the statute does not discuss punitive damages, it discusses the compensatory damages. So I'm just curious as to your position regarding the calculation of punitive damages as to the Lanham Act.
It's absolutely right, Judge Benjamin. So that's the one claim that both sides agree is not eligible for punitive damages. Now, the jury didn't award punitive damages on that claim. It wasn't instructed it could award punitives. It was instructed it had other claims it could award punitives on. So it awards punitive damages on other claims, and then the North Carolina statute steps in and says, oh, we set a 3-to-1 cap. Now, they say, oh, well, if you roll all the claims in to do the 3-to-1 cap, you got punitives on the Lanham Act claim. No, you didn't. The jury didn't award punitives on the Lanham Act claim. The jury awarded an amount of punitives on the other claims. And then the only thing the North Carolina statute says is add up all your compensatories, run a 3-to-1 against the punitives, and that's how we keep from having runaway punitive judgments in the state of North Carolina. So the only question that I think they've got on the table is when the North Carolina statute says add up all the compensatories, do you do it sort of just claim by claim, or do you add up all the claims, including the Lanham Act claim? And we already know from the North Carolina Court of Appeals in Ryan that the answer to that is you add up all the compensatories. That's how you run the 3-to-1 calculation. All I would say, Judge Niemeyer, is there's a lot of different arguments that have been sort of thrown at the wall on damages. I don't think most of them are preserved because of the way the jury was instructed and the verdict form. I don't think you can slice and dice the categories, but if you do, there was ample evidence in front of the jury for all of these. This was not a runaway jury. This is as bad a case of competitor misconduct as I have ever seen, and they're not here disputing the facts. No one is here saying Vivint didn't do this. This was a jury faced with extensive evidence of some really bad conduct. It entered a compensatory damage amount that was between what the parties wanted, and then it entered a punitive damage amount that was not runaway. It was in the 3-to-1 cap. This was a jury that acted reasonably based on the record before it.
It was within the cap. Was it at the cap or was it below the cap?
It's below the cap. No, it's not below the cap by a lot because the compensatories were just under 50 at 49.7. So that would have given you about 149, and they came in at 140. So it's under the 3-to-1, but it's close, right? And I think that, I don't think that's a problem. In other words, the jury had in front of it egregious misconduct. The jury was perfectly entitled to go right up to the 3-to-1 cap. They had customers, I mean, not just the customers, right? You had the former vice president of Vivint, Scott Bell, who got on the stand and was asked, when you were at Vivint, what deceptive practices did you see? And here's the quote from the record, name it, end quote. And then their former employee said, we trained these people to do this. We rewarded the ones who did. He ran through all of it in front of the jury. This was not a runaway jury. This was a jury that said, we're going to award a reasonable amount of compensatories given the harm. We're going to go right up to the cap, but not above, right? You had two good district court judges who looked at the kitchen sink of arguments, rejected them all. Judge Cochran's post-trial opinion, I think, is very thorough and very good on this. This is a verdict that really ought to be affirmed.
All right, thank you.
Thank you.
All right, Ms. Thompson?
Thank you, Your Honor. Let me start where Mr. Wall left off on the punitive damages issue. The jury actually was instructed that they could only award punitive damages if they found liability on the unfair competition claim or the tortious interference claim. That's page 1876 of the record. And that's a correct instruction because those are the only two claims eligible under North Carolina law for punitive damages. If Mr. Wall were correct in his argument, then quadruple damages could be awarded for a UDTPA claim, which is what they're requesting here from this court, that punitive damages be awarded on the UDTPA claim, so we're not trebling those damages of $29.3 million, we're quadrupling them.
I think what he's arguing is that the damages are not, the trebling is not done claim by claim, but rather as a bucket, so that there's a calculation that's made, and then that's frozen in time, and then the jury can go up to trebling that total amount. And that would be true with regard to the Lanham Act claim, just as it would be true with regard to the UDTPA claim. And so it's really just a difference of at what point the trebling calculation is determined, not which claims it's determined on.
Well, no, Your Honor, I don't think that's correct. It is which claims are eligible for punitive damages. The court in the Ryan case specifically states that they're talking about claims subject to punitive damages. And CPI concedes in this case that the Lanham Act, which is not eligible for punitive damages, should not be included in calculating the punitive damages cap. Why? Because otherwise punitive damages are being awarded for claims that aren't eligible for them. If you had a breach of contract...
It may be subtle, and I haven't thought this out fully, but I think the argument I heard from Mr. Wall was that the punitive damages were awarded on the claims for which punitive damages can be awarded. And then once they're awarded, they're capped based on all the damages.
Right, and that's exactly what we're saying is contrary to North Carolina law. And there's a good example. If you have a breach of contract claim, no punitive damages, you get $1.
What does the statute say? The statute says, the jury was instructed, as you say, to award punitive damages only with respect to certain claims. And we presume that the jury followed the instructions. Now, the question now is where was the award of punitive damages excessive, not whether it was awardable, but whether they were excessive in amount. And the North Carolina statute says to look at all the compensatory damages to determine whether it was excessive. This is to satisfy, I guess, the Supreme Court's due process notion about punitive damages.
Again, the North Carolina courts, when looking at this issue, have looked at claims that are eligible for punitive damages. And I
That's for the
believe
award.
for the cap calculation. And that is absolutely what the court says in Rhine, the North Carolina court says in Rhine. And in the case that CPI has cited, where they're saying the district court in Southpaw included the UDTPA claims in the punitive damages cap calculation, that's incorrect. That was a magistrate judge's decision that on objections to the district court, if you look at that decision, the district court decision, there are no punitive damages awarded on that UDTPA claim. So there's nothing that CPI can point to in all of North Carolina law awarding punitive damages on a UDTPA claim. This court shouldn't be the first to allow that in the calculating the cap. But let me just also briefly turn to the question of the total number of damages, because there is a great concern here that this is an excessive verdict against the weight of the evidence, and I heard your questions on disgorgement. Let me be clear. What CPI was quoting for the 20 to 1 multiplier is this same page of testimony. It's excerpts of record page 1023. Quote, yes, I mean, as you can see, there's some variation in the studies. You know, some say 95%, some say 97%, some say, you know, more than 1/3 takes no action. You know, it's a bit across the map in terms of what the conclusion is. That's what they're relying on to have this multiplier. And why is this important?
They're also relying on the fact that in a case in which you were plaintiff, you argued for 4%.
But there's nothing connecting any of that admission on a 25, 30-year-old study in that case to what happened here with these customers. And that's what the jury's award has to be based on. So just taking your question about disgorgement, if we have, say, a 2 to 1.
And did you put on testimony that it was 2 to 1?
That's right. There was testimony that it could perhaps be 2 to 1.
The fact that there's unreported claims is undisputed.
That's true, Your Honor. But if it's 2 to 1.
It's just the amount, right?
And it's a swing of tens of millions of dollars. If it were 2 to 1, maximum disgorgement would have been about $4 million. Maximum corrective advertising, 10.8. Maximum goodwill, 13.5. Maximum avoidance cost, 1.5. What is that total? That totals approximately $25 million. There's no basis to get to a $49.3 million compensatory damages award that then is subject to punitive damages. So for all of those reasons, a new trial should be granted, at least as to damages.
Thank you.
Thank you, Your Honor.
We'll come down and greet counsel
Thank you.
and proceed on to the next case. Next case we'll hear this morning is Jensen versus Maryland Cannabis Administration. And Mr. Jensen, whenever you're ready, we'll hear from you. Within reason.
Thank you, Your Honors. May it please the court. I'd like to begin with the two questions that the court directed me to address. Is the court able to hear me? The first is, what is the status of the social equity licensing process? The applicants for provisional licenses were selected in the lottery. Beyond that, I don't know the status of them converting to final licenses. The state would have to answer that. To To address the court's second question, how does selecting the applicants in the lottery impact the relief in this case? It doesn't affect it at all, for multiple reasons. First of which is the defendants have conceded that it doesn't make any difference.
Keep your voice up, please.
Yes, Your Honor.
You're speaking to us, not down to the
Okay,
podium.
Your Honor. The second question was, how does selecting applicants in the lottery affect the relief requested? And the answer is it doesn't affect the relief for multiple
Let me ask you
reasons.
just on that point. All the licenses have been issued?
Well, it's a multi-step process to get a
My
cannabis
question is,
license.
have all the licenses been issued?
I don't, to my knowledge, no licenses have been issued. The number of people, take for example retail, there are going to be 80 licenses granted. 80 people were selected for provisional, I don't know the term they use, but then if I can, for example, in the defendants, the plaintiff moved to expedite the appeal. The defendants opposed. On page 5 of their opposition, which is document 13.1, they talk about some of the steps that are necessary for the people selected in the lottery to get their license. And selected applicants may now pursue a conditional license and then full licensure.
How many licenses are authorized?
I don't know on the total one. I know
1,700, isn't it?
no, there were 1,700 applicants. There are 80 retail.
I don't mean 1,700, yeah, there's a much lower number of licenses.
There are 80 retail licenses, and then in addition to the cultivation and
And how many on each of those categories?
I'm not sure, those were not the ones we were pursuing, but I can tell you in just one moment because it's addressed in the,
All right, stick with the 80, that's fine. So have any of those been issued?
to my knowledge, no, but I'm taking that solely from the defendant's opposition to our motion to expedite, which was
Well,
filed
that's
back
a
in
while
March.
back. We'll hear from
Right.
them then.
Correct. But I would like to point out that they have conceded it makes no difference. In their opposition to our motion to expedite, on page 2, they wrote, this is, again, document 13-1. In short, to the extent that the court resolves this appeal within the next 12 months in the normal course, an expedited appeal is unnecessary to preserve Mrs. Jensen's ability to pursue the remedy of enjoining cannabis licensure based on the criterion she alleges is unconstitutional. And that goes to the steps that the selected people in the lottery have to take to get their licenses.
So what exactly is the remedy you're seeking at this point? I understand what you were seeking at the time the complaint was filed. I've read your complaint. What remedy are you seeking now?
We're seeking an injunction against issuing of any licenses under
But
the
the state's
program.
already issued provisional licenses, and I would assume those individuals have begun setting up their businesses. Perhaps they're already set up?
I don't know the status of them doing it. According to the state, they wouldn't have been able to get the businesses set up by now. In New
But
York,
Isn't this, then the remedy you're seeking retroactive? To
I don't
basically
think so.
undo what the state has already done, and wouldn't that be precluded by the sovereign immunity?
no, Your Honor, I'm seeking to enjoin final licenses, which to my knowledge have not been issued, but I do
But
want
the
to,
state would have to rerun the whole program and undo what it's already done.
that is correct. And I want to point out, in New York, they had a similar program. A difference, which is not really material, is that the people selected were not selected by lottery. They were selected in a ranked system. In that, a year after that happened, a plaintiff sued to enjoin that, and the court enjoined everybody who was not at full final licensure ready to open before their complaint was filed. So a year later. The court could do something like that in the extent that anybody does have a final license and is ready to open. I would point out that this case is quite different from New York. In New York, the people sued a year, I think it was more than a year, after the applicants were selected. Here, the plaintiff sued before the date of the lottery was even announced, yet let alone held and then the applicants selected. So if the court were to issue an injunction effective as the date of the complaint, which we feel is appropriate, that would be all businesses, all applicants. And then
So when it was filed, did you seek a TRO?
yes. And then lastly, I would point out that even if the court were to not consider that in determining whether to grant relief, there's going to be a second round, and the conditions for the second round indicate there will be another social equity. and that is the defendant's document 20 at page 38. If I can even back up one page, 37 discusses the first round, which is what we're talking about, and it talks about the social equity. Page 38 talks about the second round of licensing, and you'll notice in F1 it says, well, if I back up to E, it says the second round of licensing shall be in accordance with F or G of the section. Then down to F, the last sentence of that paragraph says applying minimum licensing qualifications, employing remedial measures consistent with the constitutional requirements, and not more than, talks about the licenses. The last sentence on that page again says, towards the end, the administration shall award licenses under paragraph 1 of this subsection through a lottery process that employs remedial measures. So the remedial measures are not yet defined for round 2, but it's pretty clear where it's going. That's going to be another social equity program, and it will be another unconstitutional provision. So I
Let
would,
me ask you on the constitutionality. First, unlike, for instance, the Massachusetts program, any resident from anywhere in the country can be a licensee.
provided they meet the qualifications, correct?
Well, yes, but those are uniform for everybody. And every social equity applicant can be from a resident of anywhere in the country, too. And the requirement for social equity is the public policy to basically engage people who have been down and out, who've been disproportionately suffered with respect to the drug wars, to give them a privilege to be a licensee. But it does not restrict those social equity to residents of Maryland or elsewhere. It's nationally. So the question is, how do you qualify to be a social equity, get that privilege? And you qualify by one of the 3 standards. And the 3 standards includes persons who attended 6 schools in Maryland where there are a lot of down and out students who have had experiences in life based on the Pell Grants, experiences in life that serve the public policy. My problem with your argument, at least at this point, I'm posing it because I want to hear your response, but my problem with your argument is, number one, a licensee, standard licensee, can be from anywhere in the country. The state clearly did not require any kind of residency requirement. And for the board members, ownership members, cultivation members, or anything. What it does have is a public policy that a group of the applicants should be, have this experience. But again, even with respect to that narrow group, it doesn't say you have to be a resident of Maryland or a resident of Pennsylvania or whatever. What it does say is one of the experiences we value as a legislature is those who attended the 6 schools in Maryland, like Coppin State and the Morgan State and the other schools in Maryland that have this high level of Pell Grant applicants. I don't see how that discriminates against persons out of state or against interstate commerce. You can tell me that, but explain it, but your client could clearly have applied for a standard without a problem. She wants to invoke a privilege that the state chose to give as a matter of public policy, but that privilege wasn't based on interstate commerce or out-of-staters. That privilege is based on what the legislature wanted to define as socially down and out people who they wanted to get into the enterprise business.
Your Honor, that's not correct that the plaintiff could apply for a standard license. There is no standard retail license. The only way to get a
They use
retail.
the word standard. Now, tell me what it is. If you're not part of the social equity applicant pool, what are you?
You're not in the first round for
I'm not talking
retail.
about first round. I'm talking about getting a license.
There is no second round at this point. The only way to get a license.
There's no standard license. Everybody has to apply through the social equity?
In retail, correct. I can't speak to the other, I can't speak to cultivation or whatnot because we didn't pursue that. But there is no way to get a retail license unless you're social equity.
But that's just the first round. There's a second round and a third round. I mean, you just pointed out to us in the second round.
Correct. We're talking about the first round, and there's no reason why she should be
But the
excluded from
program,
it.
you're challenging the program as discriminating against interstate commerce.
Correct.
And in the end, they want, hypothetically, because I don't know exact number, 170 licenses. And 200 of those licenses are going to be social equity, and the rest are going to be what they call standard. That's the words used in the papers, standard licensees.
I don't know.
And my whole question is, this is not a program that has aimed at favoring Marylanders over out-of-staters. Out-of-staters are qualified, whereas under the Massachusetts program, for instance, the directors and owners and everybody had to be residents of Massachusetts. There's no residency requirement here, nowhere in the whole program.
There are two very distinct issues that are coming up. The first being whether you have to be a social equity applicant to apply, and the second being the Dormant Commerce Clause. I'm going to try to, in the time I have left, address both. There will be a second round. As I pointed out, the second round, it talks about remedial measures, which I assume is going to, not defined yet, but will be another social equity program. This would not be the first state that has limited all of their retail licenses to social equity applicants, even when they said we'll decide later on the future rounds, and they in the end decide that those are going to be social equity as well. To turning to the judge's question
She could still
about,
be an owner, or she would just be a partial owner,
she
right?
cannot apply. She can
could
only,
She could own up to 35%. She would have to partner with a social equity applicant, would she not?
she cannot apply, you're correct, she cannot apply on her own. The only way to do that would be if a social equity applicant agreed to take her on as a partner. I'd like to go to the judge's question about the Dormant Commerce. The Dormant Commerce Clause is clear that it doesn't have to be a full bar to out-of-state. It has to create a preference for in-state. It has to create, it has to make the in-state and out-of-state not on equal footing. I've given the,
But let me ask you this, other than regarding the Dormant Commerce Clause, other than, I know you cited in your brief this example about Merrick Garland testifying to in its confirmation process, but what other indication do you have that Congress regulates or recognizes the adult use of marijuana or cannabis, and it is a legitimate market? Because I guess I'm confused as to how you're saying the Dormant Commerce Clause applies here to something that is not recognized as a legitimate market by Congress.
The Commerce Clause and the Dormant Commerce Clause are two entirely separate powers, albeit they derive from the same constitutional provision. The Commerce Clause grant of power to the federal government is wholly independent of the Dormant Commerce Clause restriction on state protectionism. They derive from different purposes. The point of the Dormant Commerce Clause is to prevent trade wars and what they call the balkanization of the states. That is independent of the federal government, which has left cannabis federally illegal, albeit there's no enforcement meaningfully going on at this point. They are allowing the states to have these licenses, grant these licenses, and conduct business. We've seen it all around the country. And that is exactly what the Dormant Commerce Clause is trying to prevent and target in preventing protectionism of its in-state
But
people.
aren't the markets within states? They're not actually between states, because marketing between states would be federally criminal.
Well, that depends, Your Honor, whether you're talking about the product crossing state lines or the investment. And as far as product crossing state lines, that's not raised in this case. That would be a completely different Dormant Commerce Clause analysis, because under Tier 1, you have to say, this is what I'm trying to serve my local purpose, and these are my available alternatives. It would be a different local purpose and different alternatives, so it's not raised by this case. This case is solely about out-of-state investment, and that happens all over the country. Some states allow out-of-state and some don't. And in fact, this, under their argument, they are allowing out, I know I'm supposed to tell you when it goes red, they told me that in the office. They are allowing out-of-state. As Your Honor pointed out, you could potentially buy 35% of a social equity applicant's business if that applicant were willing to sell. So they are allowing out-of-state. What they're doing is creating a preference for in-state, granting the licenses.
Well, they're not creating a preference for in-state. As Judge Niemeyer pointed out, it's a preference, one of the preferences is for individuals who went to school
Well, I
in state
disagree
for
with
2
that, Your
years.
Honor. It's not a bar, it's not a prohibition of out-of-state, but I think it's a clear preference. In the record, we listed the in-state versus out-of-state students for each of the schools. It runs from, I think, in the 90% to the lowest was something like 46%.
But that's just an experience, a life experience that the legislature identified. It's not a qualification, present qualification in terms of residency, market, extensive market, where somebody lives, how much money they have to put in. I mean, it basically says they want somebody with the 3 life experiences, one of them, to qualify for, to serve the public policy. And they're familiar with those 6 institutions and said, if you were an alumna of those schools, you can use that as an experience, or you can use a grade school experience, or you can use where you lived, this type of thing. But the point is, the system is not trying to discriminate against out-of-staters, because it doesn't even limit social equity licensees to out-of-staters, in-staters.
The statute says, and I'm somewhat paraphrasing, but a school where 40% of the students were qualified for Pell Grants in Maryland.
Yes,
I believe it
there's
says in the
6
state.
schools.
6 schools, right.
I'm
And
familiar with them, yeah.
But that doesn't mean that the students are necessarily from Maryland. The schools are in Maryland, but, for example, Morgan State is 50% out-of-state students.
the Dormant Commerce Clause does not require a prohibition on out-of-state. It
No,
requires a preference.
discrimination.
Yeah.
Correct, a preference for in-state.
Well, why don't
The-
you pick this up on, we're way over the line.
Yes, sir.
Why don't you pick this up on your rebuttal?
Thank you.
Mr. Chasm?
Thank you, Your Honor, and may it please the Court, Joshua Chazen, Maryland Office of the Attorney General. On behalf of the Maryland Cannabis Administration and its Executive Director, joining me at counsel's table is Heather Nelson, counsel of record in the case as well. The District Court correctly denied Ms. Jensen's motion for preliminary injunction because she did not demonstrate that she is likely to succeed on the merits of her claim, and the balance of the equities and public interest weighed against granting the motion for preliminary injunction. Ms. Jensen sought injunctive relief and a declaratory judgment against a portion of Maryland's Cannabis Reform Act, which was passed by the Maryland General Assembly after Maryland voters added Article 20 to the Maryland Constitution. The act establishes a program through which individuals may access regulated cannabis products through licensed cannabis businesses. And part of the act addresses the criteria used by the administration when it issued the first round of licenses to eligible recipients.
What's the current state of the licensing
Yes,
program?
yes, Your Honor. And so, addressing this court's order, there were, and let me provide some data and background. So, 205 applications were selected in the lotteries. There were 174 in March of 2024, and another 31 in June of 2024. To date, the administration has issued 188 conditional licenses. That's as of yesterday. Additionally, the administration has denied 7 applications, 3 applicants withdrew, and therefore there are 7 pending review as of yesterday. Of the 205 selected applicants, 16 qualified under the Pell Grant criterion, which is at issue in this case today. And all 16, as of yesterday, have been issued conditional licenses. Conditional licenses are working towards a full license. So it requires certain things like obtaining a location, working through zoning approval. All of that is codified in COMAR 14.17.05.05 subsection 4. And the conditional license process is up to 18 months. So the administration has not issued any full licenses yet as part of this round, to be clear. And all licenses that the administration was to issue in the first round, which is the only round that must include the Pell Grant criterion, are spoken for. So Ms. Jensen's requested relief is for this court to remand with instructions for the district court to grant a preliminary injunction. That's what she wrote in her briefing before this court. The injunctive relief requested in Ms. Jensen's complaint contained two components. First, Ms. Jensen requested an injunction prohibiting defendants from taking any further steps to process any applications for cannabis business licenses from the application program that closed on December 12, 2023. And second, Ms. Jensen requested an injunction prohibiting defendants from enforcing any portions of the Maryland Code or Maryland regulations that favor Maryland residents over out-of-state residents for cannabis business licenses. Based on the lotteries that have already taken place and nearly all the conditional licenses being approved, there would be no applications left to process. The administration is left to...
Well, you didn't process any of them based on residency, did you?
No, Your Honor.
His request said based on a residency.
And that's the second part of the request of relief in the complaint. That is correct, Your Honor. And so that provision isn't even at play, period, as Your Honor is pointing out.
Residency is not anywhere as a requirement for any licensee.
That is correct, Your Honor. And so, in circling back to the argument before the court today on behalf of the administration, the social equity applicant criterion, as Your Honor pointed out, includes the Pell Grant criterion. That requires a social equity applicant to have at least one owner, one or more individuals. They have to have at least 65% ownership interest, who for at least 2 years attended a 4-year institution of higher learning in the state, where at least 40% of the individuals who attended the institution are eligible to the Pell Grant. This court is well aware of that. I know Judge Niemeyer noted the 6 institutions. And there's the underlying fact that Ms. Jensen never submitted an application. So Ms. Jensen submitted a request for information with the administrator. The administrator told her, under the facts alleged in the complaint, that she attended CSU Long Beach, and that's not one of these 6 institutions. Therefore, she would be ineligible under this criterion, and she didn't submit that
Well, under that one,
application.
she could qualify under the other two, or she could just get a standard license for something else.
That's right, Your Honor. And so all that's at challenge here is this third criterion, the Pell Grant criterion. And Ms. Jensen claims that it unconstitutionally discriminates against out-of-state residents under the Dormant Commerce Clause. That argument fails for 2 reasons. First, it's our position that the interstate market in recreational cannabis is illegal as a matter of federal law. And second...
Yeah, but that hardly holds water, because illegal markets that's the reason they're regulated. I mean, the federal government regulates illegal markets in guns and drugs. And so it seems to me the better argument is that there's no residency requirement.
And we're happy to rely on the papers as to the first piece of that argument, Your Honor. And so the second piece, as I'll get to, it doesn't favor Maryland residents. It applies equally to out-of-state residents as it does to Maryland residents. And for those reasons, the district court was correct to conclude that Ms. Jensen was unlikely to succeed on the merits of her claim. So, assuming the court disagrees with the state's position as to the first piece, that the Dormant Commerce Clause does not apply here to recreational cannabis.
I do have one question regarding, he cites the Gonzalez case, which does apply, where the court said that Congress does regulate the interstate market there. I'm just trying to understand how this case is distinguishable from that case.
So, yes, Your Honor. So, in Gonzalez, there is an acknowledgement of the existence of an interstate cannabis market, and it upholds Congress's authority to prohibit the possession, cultivation, and use of cannabis in a purely intrastate manner in a state where medical cannabis was legal. And so the holding from Reich, Gonzalez v. Reich, isn't necessarily applicable here because it doesn't contain any provisions related to medical cannabis. And that sort of relates to the Northeast Patients Group case, the First Circuit case. We have a difference of opinion from my friend on the other side as to how that case applies. Again, that dealt with Maine's Medical Marijuana Act. And
I kept referring to Massachusetts. I meant Maine.
Maine, yes, Your Honor.
Maine's provision has a residency requirement.
It does.
And it seems to me that is not only materially, that's almost central to the whole analysis. That makes this one different.
That is our position, and there's also the Rohrabacher-Farr Amendment, Your Honor. It prohibits the use of federal funds to oppose state medical cannabis programs, the key distinction, medical there. So the First Circuit holding is limited in its reach, and that's why we designate the difference. But even if the court disagrees with the state's position here, and it undertakes the Dormant Commerce Clause analysis, the result shows that the district court correctly concluded that Ms. Jensen failed to show a likelihood of success on the merits. So we start first, this court starts first, with asking whether the state law discriminates against interstate commerce. There is no differential treatment between an in-state and out-of-state economic interest through the Pell Grant criterion. There's no state protectionism designed to benefit the economic interests of the state, because an individual can reside outside of the state but still attend one of these 6 institutions. We're not aware of anything in the factual record, nor what's publicly available, that these institutions don't allow out-of-state or non-American individuals to attend those institutions. And the criterion applies to Maryland and non-Maryland individuals alike. Out-of-state residents simply are placed in the same situation, the same place, as their out-of-state counterparts, or Maryland counterparts, excuse me. That's not discrimination. And so we have these 6 institutions. In the reply brief, Ms. Jensen notes that the appellee's application program discriminates against applicants who have never lived in Maryland, and that's simply not true. So, and it's easily refuted. So take, for example, Washington Adventist University, one of the 6 institutions. According to its website, WAU School of Graduate and Professional Studies offers 4 undergraduate programs that are fully online. And in another example, the University of Maryland Eastern Shore offers 5 bachelor's degrees programs in a fully virtual format.
Well,
So
this gains you nothing. I mean, none of these universities restrict admission to Maryland residents. I mean,
I think it's important,
there are
and
alumni and alumna of all out-of-state, of all these universities. I mean, this is not challenged. It's
I think the point that we're trying to make there in response to the reply argument, Your Honor, is that you actually don't ever have to have even stepped foot in the state of Maryland to qualify for this Pell Grant criterion.
oh, because you could have done it online.
That is correct, Your Honor. And so that argument was presented in the reply brief, just making that reference. So that goes even further to show that there are no in-state interests protected against out-of-state interests. With the determination that the Pell Grant criterion does not discriminate against interstate commerce, the court then considers whether the state unjustifiably burdens the interstate flow of articles of commerce. That's the Pike test, of course, but there is no flow of commerce from out of state. The licenses are designed for individuals who are going to have businesses in the state of Maryland.
Is there a limit on the number of licenses that will be granted?
So under the statute, in total, there are certain limitations that get set. And that's, I believe, I'm just trying to get my number correct on the statute piece. It is attached as part of the brief, but section 36401 of the Maryland Code annotated alcoholic beverages and cannabis article, sections E, F, and G. And so there's consultation that takes place. But there are certain limitations in place now, but of course that can be adjusted.
I'm trying to understand whether the program has set a number, or a regulation has set a number, or is that indefinite?
I don't believe that the administration has set a specific number at this time, Your Honor. It sets a certain number of licenses that can be issued in each round. So we had the first round where the lottery occurred. There's a statute that deals with the second round, and so those have set numbers as are statutorily provided, but there's no set number in the scheme in total at this time about the number of licenses that are to be issued.
What round would she be able to apply in?
So the key piece to that, Your Honor, is that she would be able to apply in any round, assuming she meets the qualifications. So assuming she's not qualified under the social equity applicant criteria, the Pell Grant criteria only applied in round 1. That's the only round where it must be applied. And so we look to the second round, and the statute makes it clear there are measures that are to be supported, and it needs to award licenses under paragraph 1 of the subsection. That deals with the governor's, working with the Governor's Office of Small, Minority, and Women Business Affairs. That statute reference is at page 38 in document 20.
But she's not challenging the second round.
No, Your Honor, we're only here on the first round. So
Can we get back to your colleague's argument about the residency requirement? I understand his argument to be that although that you don't have to be from Maryland, there's a disproportionate advantage because these schools have either at least half or a majority Maryland students at the schools. So he's sort of making a disparate impact argument under the Dormant Commerce Clause. And I'm not aware of cases that make disparate impact arguments under the Dormant Commerce Clause, but that seems to be what he's saying. Not that it's a perfect Venn diagram overlap of everyone that qualifies is a Maryland resident, but that you're more likely to be a Maryland resident if you qualify.
So in addressing that argument, Your Honor, it's Ms. Jensen's burden to show the constitutional violation. We've heard pieces from and I believe there are references cited in the joint appendix about the percentage of students at each of these institutions who qualify as in-state versus out-of-state residents. There's no data to show what happens to those individuals upon their leaving the university. And so all that data shows is the percent of students who attend those universities who qualify for in-state tuition or out-of-state residents. It doesn't show that those percentage of individuals reside in the state following their attendance or graduation from these institutions. And that's her burden to show that data. She didn't do that. It's absent from the complaint as well. And so even taking the stretch of the disparate impact argument, as Your Honor is presenting it, that my friend on the other side is presenting here, it's not an argument that can go far enough, and it's Ms. Jensen's obligation to satisfy the constitutional violation standard. She made no effort to tie where these individuals live. And again, I pointed it out as a response to the reply argument, but there's no requirement that these individuals, whether they're in-state or out-of-state, technically have to live in the state during their time studying if they're in an online degree program. And so the same reasons that the Pell Grant criterion does not discriminate against out-of-state interests, it places no undue burden on out-of-state interests, and that's the test that the Supreme Court has elicited from Pike and also, I think, reaffirmed as a result of the pork producers case from 2023. Simply put, the regulation applies equally to in-state and out-of-state interests. It does not offend the Dormant Commerce Clause. Finally, the district court did not abuse its discretion, concluding that the balance of equities and the public interest weighed against granting a preliminary injunction. Ms. Jensen didn't bring the lawsuit until after the application process had largely played out. Ms. Jensen's counsel acknowledged at the hearing on her motion for preliminary injunction that Ms. Jensen most likely learned of the application lottery in September of 2023, months before the deadline to submit an application to be eligible for that lottery. Her first contact with the administration was on December 28th, 2023, after the window had closed. She filed her complaint on January 26, 2024. Her motion for preliminary injunction followed later on February 6, 2024. By waiting until the process had neared its conclusion, until acting, Ms. Jensen acted unreasonably. The application process necessitated hundreds of thousands of dollars and hundreds of staff hours to process, and that's only for the administration. Of course, there are the individuals who actually took the time to apply. We're not speaking on that data, of course. They're not a party to this case, but naturally, a decision in this case would impact those who have already received their conditional licenses and are working towards a full licenses if the process were to totally start over. And I don't even know that that's the specific relief that Ms. Jensen has requested in this case, but it goes against the will of the Maryland voters. They overwhelmingly decided to enshrine the right for an individual of 21 years of age or older to use and possess cannabis and command the state to create a regulated adult use cannabis regime. And it did that. And so delaying licensure would further frustrate the purpose of the act and undermine the will of the voters.
Can you buy cannabis in Maryland now?
You can, Your Honor.
Not me, please.
Sure. Well, anybody over the age of 21 or older can buy it.
Yeah.
So if that does not disqualify you, then yes, Your Honor. And there are retailers who were part of a program. One of the questions that this panel had asked my friend on the other side is sort of this standard license. And so standard means that you can sell both medical and recreational, but of course there are other pre-existing licenses that are not part of the social equity program. Most of those generated, of course, from medical cannabis use in the state of Maryland. And those retailers were eligible to be able to sell their products for a recreational purpose as well. presuming they met all requirements under Maryland law to do that. So individuals can currently go there. The regime has been set up. The idea is to, and this again goes to the public interest piece, prevent sort of the dark market from being the prevailing market in the state of Maryland. It really prevents the state from protecting the health and safety of Marylanders, so who enshrine this right in the Maryland Constitution, but of course the state has an obligation to make it safe, to make sure that these licensees are not exhibiting behaviors or selling products that would be harmful to the Maryland consumer who is eligible to purchase these products. For these reasons, the district court did not abuse its discretion in denying Ms. Jensen's motion for preliminary injunction, and appellees respectfully request that this court affirm the judgment of the United States District Court for the District of Maryland. Thank you very much.
Mr. Jensen?
Thank you, Your Honors. The Maryland legislature could have set a rule that said, in order to qualify for social equity, you have to attend colleges that 40% of the students qualified for Pell Grants in California. Can you imagine the uproar from the Maryland voters if they had done so? Because they know that having that rule for Maryland favors Maryland residents. If they had said it in California, that would have been a disadvantage to Maryland residents. We put in the brief the student breakdown for the 6 colleges. It ran from the 90% down to 50%. Even if you take the one school that was closer to 50%, Maryland residents don't represent anywhere near 50% of the residents of the country.
We don't know who was a resident before they attended college, during college. You do know during college.
Correct.
And you don't know after college. In other words, this program is written today. It doesn't say you have to be a resident of Maryland. It says if you want to qualify as a social equity licensee, you have to have had one of 3 experiences.
Correct.
And they describe those 3 experiences. But it still applies to out-of-staters, and the people who attended that school could be out-of-staters. I'm sure there's we don't have the data in the record, but we have nothing to say that everybody who graduated from these schools stayed in the state.
Judge Berner mentioned that she's not aware of practical effects. I forgot the exact word she used for a dormant commerce clause. On page 15 of the appellant's reply, we do state that and we quote the, I guess, Fourth Circuit, a state directly regulates, discriminates against interstate commerce, or its effect is to favor in-state interests over out-of-state. So there is an effects portion of that. And again, if you turn the page to 16, again, we quote a couple of cases where if a state law discriminates facially in its practical effect or in purpose, where 5 of the 6 colleges are in, I believe, the 80 or 90% in-state residency, I think that's a pretty clear practical effect of favoring Maryland residents, regardless of what percentage may later move out, or people may.
I mean, you're looking at the data of the number of students that are enrolled currently, and they don't qualify. We're talking about graduates, someone that graduated from Morgan State and moves to California. That person can apply, correct?
This isn't really a point of what you're saying, but they don't have to graduate. They have to go for 2 years. But yes, a person who graduates from one of the listed colleges and moves to California could apply. That's
But
correct.
I guess what I'm saying is the measure that you're using are students that are currently enrolled.
Well, I use the only data that's available to us.
All right, but but there's no data regarding students who have since left or attended, I guess, since you said they didn't graduate, and moved somewhere else. There's no data in the record regarding that to show any discrimination.
I agree with part of what you're saying, disagree with part. I do not have the data on who moved out of state. As far as no data showing discrimination, I think it's pretty clear that in practical effect, limiting to 6 colleges, all of which is in Maryland, is going to favor Maryland over.
It doesn't limit it. That's my whole point. It's a privilege that's extended to those people. But you could qualify also under the other 2 provisions.
But she doesn't qualify under them.
I understand, but the legislature is entitled to put some privileges and give benefit to the social equity. It doesn't say you have to be a resident on any of these. and they're talking about life-type experiences. And even the first two qualifications don't have to be experienced in Maryland. They could be experienced in New York City.
The point,
question is, do you have evidence here that Maryland is intending to discriminate against out-of-staters in favor of in-staters? And it's hard to see when they have one of three privileges, any one of which would qualify, because that's in furtherance of its public policy. Now, you'd have to attack its public policy. You know, somebody who doesn't fit the social equity, let's take away the third one and just have the first two. They could have said that. The question is, isn't that something the legislature can do, is limit it in favor of public policy?
We aren't
This is not based on interstate commerce or residency. It's based on a type of experience that the applicant would have, which is intended to promote enterprise for the down and outers, to bring them into the enterprise business.
the plaintiff meets that qualification. The plaintiff went to a college where at least 40% of the people qualify for Pell Grants. That wasn't in Maryland, which is the whole point. The legislature can select people, you said, based on life experience. What they can't do is they can't violate the Dormant Commerce Clause. If they had left those three words in the state off of the end of that statute, then we wouldn't be here. The point of this is that they didn't just
Well, those happen to be the 6 states with which the legislature is familiar. They're in-state. There's 6 schools that have a population attending them who have come from poor economic circumstances based on one measure that they've selected. And the question is, when they do that, they're looking for a type of person who is not in-state or out-state. They're looking for a type of person who has had experiences in the drug wars, had been disproportionately affected in connection with that, and to get them engaged in this process. That's the public policy.
The public policy doesn't say anything about the engage in the drug war. It says a school where 40%,
Impacted by the war on drugs. That's the language.
that's their justification for it, but
That's the
the
policy.
the qualification is having been a student for at least 2 years at a school that has 40%, but that doesn't require that a person, for example, some states say you have to have been actually arrested or had a parent or child who was arrested for a cannabis crime. They don't have that. So they're treating everybody who went to a qualifying college equally, whether that person was arrested or had a parent or child arrested or not. They could have given that same experience to anybody. The statute does not say 6 colleges. It says 40% in the state. They left it to, I believe it was the agency who identified the 6 colleges. So they could have left that to the applicants to prove that their college had 40% Pell Grants. The state didn't have to take on that burden. They could have said, if the point of this is that people went to schools that reached 40% Pell Grant, and I don't know if you have familiar with Long Beach or not, but you know that is certainly an area where has effective cannabis and other drug prohibitions. They could have served that.
Well, they could have done a lot of things. The question is whether what they did discriminates. And
I agree with you.
That's the question before us, and we'll have to take that under consideration. But thank you very much. We'll come down and greet counsel and then take a short recess.
The Honorable Court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. All right, we'll hear the next case of Moore versus State of Maryland. Mr. DiMichelli.
Yes, Your Honor. May it please the court, Andrew DiMichelli, Maryland Office of the Attorney General, on behalf of the state appellants. The state appellants in this case are asking the court to reverse the district court's grant of federal habeas relief on 3 grounds. First, without input from the petitioner, the district court improperly identified a Brady claim that Mr. Moore chose not to present to the court. It counseled Mr. Moore to amend his petition to raise the claim, and then it granted relief on the claim. That was a reversible error according to this court's decision in Folks. The second issue we're presenting to the court is that Mr. Moore's Brady claim was procedurally defaulted, and the district court erred in concluding otherwise and addressing the claim on the merits. And finally, with respect to the merits of Mr. Moore's Brady claim, the district court failed to properly defer to the state court's reasonable decision as the AEDPA standard requires, and it also misapplied the Brady favorability and materiality prongs.
You know, the whole factual issue underlying all of these grounds that you've alleged, and we should be happy to have you discuss those, but seems to rest on the notion that the two chain of custody reports have some kind of tension between them. And I'll ask counsel for the other side of this question, but I have compared the two reports, and they seem to be consistent to the minute.
That is our position. They
Well,
are
it's
not.
It's right on the face of the report. You can trace it out of the evidence unit to the lab unit, from the lab unit into the lab vault, out of the lab vault to the expert who did the thing, back into the lab vault an hour later, and then back to the equity unit. And every one of those is documented to the minute. And if there's no inconsistency, the whole thing goes away. I mean, there's nothing, the argument was that the inconsistency created an ability to question whether the lab work was ever done. But if it's consistent, it seems to me you can't draw that inference and use that impeachment evidence. But I'll hear you, and I'm going to hear your lawyer. He disagrees with me violently, but we'll see.
Well, I couldn't agree with you more, Your Honor.
He's been before us many times, so.
I absolutely agree with your assessment. There is no inconsistency between the documents. They are entirely consistent.
I can't even see what the argument is for the inconsistency.
Well, I'll let my friend on the other side explain his position. I guess
Well, let me ask you this, but how can we consider them together when only one of them was produced through discovery? I understand what Judge Niemeyer is saying, but that would be, I think the argument is one was not produced and the other one was produced. And so how can we consider them together if one of them was not produced?
well, in terms of the Brady analysis, of course, you have to look at suppression, favorability, and materiality.
But in the first report, the name of the chemist wasn't in the chain of custody, and the chemist was the key witness, so isn't that material?
Well, the chemist's name was not in the report, but it didn't necessarily, that doesn't mean that the documents are inconsistent. The ECU
No, the
chain
documents
of,
aren't inconsistent, but the defendant could have used the report with the chemist's name for impeachment and for evidence at trial. It didn't have it in time.
the defense could have used it for impeachment because ultimately the document was
And was
introduced.
deprived of using it for impeachment because the defense didn't receive it in time.
Well, it is the state post-conviction court's decision that it was introduced in time for the defense to use it at trial, and that decision was not objectively unreasonable under the AEDPA standard. But with respect to the favorability and materiality prongs, which were not directly addressed by the state court in its final decision, it's our position that the documents were not favorable to Mr. Moore because, as Judge Niemeyer pointed out, they're not inconsistent. They could have, in theory, attempted to impeach the chemist, but it would have led to nothing because the documents carefully lay out the chain of custody from beginning to end. They are not inconsistent. They were never intended to, the ECU chain of custody document is not intended to reflect transactions at the laboratory. That's what the laboratory form does. They are perfectly consistent, and I think that the state would have surely pointed that out for the jury, and in doing so, in raising this whole issue, as I think the post-conviction court pointed out, the defense runs the risk of merely highlighting the illicit nature of the drugs and compelling the state to demonstrate how it was in fact carefully documented.
But Brady requires that the defense make that decision itself and receive the information to allow it to make the decision. But if the defense didn't have the information, it couldn't make the decision in time.
Well, again, I mean, I think if you're referring to the suppression prong, it was the state court's decision that it was not suppressed. It was introduced in the middle of the trial, granted. But the defense at that point, the chemist had not testified. The defense had time to look at the document. There was, I believe, an hour-long recess in the middle of the trial. There was ample time for the defense to look at the document. Defense counsel testified that he had never in his career seen such a document.
But the interesting thing about the state court orders is the state court on the issue of ineffective assistance of counsel said that counsel was not ineffective because counsel didn't have enough time to compare, to look at the document because the document wasn't produced.
I think that the state court's decision was a little bit more nuanced than that. In a nutshell, the court concluded that the evidence wasn't suppressed because the defense did have time to use it, but that trial counsel wasn't ineffective because he failed to do so.
Well, no, he said, it said it wasn't reasonable for counsel to be able to look at the document and effectively, and so therefore counsel was not ineffective. Because counsel couldn't, it wasn't reasonable to think the counsel was gonna be able to review the document during the trial. But then, as to the Brady claim, the state court says, yeah, well, counsel could have taken and looked at it because it was presented during trial. So those two things to me kind of
But I think
conflict.
that the second part is the critical piece, that counsel could have, but the fact that he didn't and focused his attention on pursuing the trial defense that he had chosen, which was trying to undermine the credibility of the officers, wasn't ineffective assistance of counsel. That ultimately, trial counsel provided Mr. Moore reasonable representation and that he was not deprived of the Sixth Amendment right to counsel. Counsel could have used the document, but the fact that he failed to do so doesn't amount to a Sixth Amendment violation. Of course, this is the merits of the issue, and I would submit to the court that the district court below never should have reached the merits of the issue for two very significant reasons. The first is that the record is clear that Mr. Moore never raised the Brady claim in his initial habeas pleadings. On March 13, 2023.
He was acting pro se, was he not?
He was.
And we're to construe pro se litigants' pleadings liberally.
I think that you are supposed to construe them liberally, but to a certain extent. You can't inject a claim that, as the district court itself found, Mr. Moore chose not to present.
He also chose not to appeal it in the state court.
That is our second issue, and I'm happy to address that now if you'd like. But
Well, it's pretty clear he identified in his papers that he had raised it below, but then he chose pretty clearly not to present it on appeal.
that is our interpretation of the documents, absolutely. He presented his application for leave to appeal to the Appellate Court of Maryland on a pre-printed form petition, which had two clearly defined parts. A background statement of facts section where he was to list the claims that he raised below, and an argument section where, as the Maryland rules require, he is required to specify his claims. He's required to identify the
But doesn't he
arguments.
identify the Brady violation claim in the allegations of errors page that he attaches to? I mean, once again, we're dealing with someone that's pro se, but he does, in the allegations of error, attach, I think it's at JA 135 or 136, where he says that the question, is there a Brady violation?
He did present the question, I think, in response to the procedural history section of that form. the court has a section on the first page that asks the petitioner, or the applicant in this case, to identify the claims that were raised below. And because
Isn't
he
the
didn't,
ineffective assistance of counsel intertwined with the Brady claim? Isn't that what Unger tells us, that we need to not
Unger
find that there's a
refers-
procedural default?
Unger refers to claims that are inextricably intertwined, in the sense that a court could not address one without the other. And we submit to the court that that is not the case for a Brady and a Strickland claim. That they are absolutely separate, they are distinct, and despite the factual overlaps in this case, the district court did not need the Brady claim in order to adjudicate the Strickland claim. And in fact, if the court looks at the district court's interim opinion, March 13, 2023, the court concludes that the state post-conviction court was not objectively unreasonable in applying the Strickland performance prong, and therefore the claim was decided at that point, which brings me back to our primary argument. The issue with the Strickland claim had already been decided by the time the court decided to identify the Brady claim, appoint counsel, request briefing, and essentially counsel Mr. Moore to raise the claim. And that is a direct violation, we submit, of this court's recent decision in Folks. That's exactly what happened.
But Folks was a little bit different, because in Folks, the district court there set out 7 different claims and asked the counsel to address those claims. Whereas here, he says file the appropriate motion. He doesn't tell him what motion to file. He says file the appropriate motion. I think he says I'm gonna appoint counsel and give you opportunity to reframe your complaint and appoint, and you can also file the appropriate motion. But he doesn't tell him, what motion you need to file. He just says appropriate.
In order to bring the Brady claim before the court, I don't think there's any question about what the district court was asking Mr. Moore and his counsel to do. The court was talking about reframing the petition. It asked the parties to address the Brady issue, to brief the Brady issue, and to the extent that the Brady claim wasn't before the court, which it wasn't, I think the court recognized that, he told Mr. Moore and his attorney to file an appropriate motion so that the court can consider the Brady claim.
But Folks talks about expanding, and I think because in that case, there were additional 7 claims. It just seems a little different than what happened here in this case versus Folks, where there's 7 additional claims that are, and so in that case, this court talks about expanding the claims.
I think, honestly, I submit to the court that this case is worse than Folks, because in that case, the expansion of the petitioner's petition was really quite small, in my opinion. And here, the court didn't just sort of expand an existing claim. It added, in essence, a claim. It raised an entirely distinct claim. Brady is not Strickland. It is entirely distinct. So
Well, they're entirely distinct legal claims, but they're based on the exact same facts. And that's the Unger issue, and that's the issue here, that there's no introduction of new facts. There's a different argument based on the same facts.
it is the same underlying facts, but the Brady materiality prong and the Strickland prejudice prong are certainly similar. But there's no overlap between the Strickland performance prong and the Brady suppression prong. And ultimately, they're not inextricably intertwined. That's what Unger is talking about. If, in theory, the defense, if Mr. Moore, for example, had conceded that the claim was procedurally defaulted, the district court could still...
Unger doesn't say inexplicably intertwined, it says sufficiently interrelated. That's quite lower standard than inexplicably,
I recall it saying inextricably intertwined.
It is settled principle of Maryland procedure that for purposes of preservation in various contexts where the issue raised by the litigant is sufficiently interrelated with another issue not raised, the court will treat them as if both issues are raised by the litigant. That's the language of Unger.
I'll have to review it again, but my reading of that case is that the court was indicating that in a situation where the claims cannot be reviewed separately, there is not a preservation problem. But when they can be reviewed separately, as in this case, the petitioner has to raise it. And I think that that's what the habeas rule 2C says, that the petitioner has to specify the claims he's raising. And he didn't in this case. And that's what the district court found. The district court found that he did not specify a Brady claim, that he chose not to present that claim. And therefore, the district court, I think, was not permitted under Falks to expand a petition or to essentially inject a dispute into the case that didn't previously exist among the parties. In this case, Mr. Moore chose not to present that claim, and the court concluded that his Strickland claim was meritless under AEDPA review, and therefore the case should have been over at that point. There was nothing else for the court to explore. The court had already concluded that his remaining claims were meritless or unreviewable, and the case should have been over. And again, to sort of return to the point that I wanted to make earlier, if Mr. Moore had in essence conceded that the claim was procedurally defaulted, which he didn't, but in theory, if he did, the court wouldn't have been precluded from addressing the Strickland claim without addressing the Brady claim. Certainly they have factual overlap, but the court didn't need the Brady claim in order to address his Strickland claim, especially considering that it had a complete record from the state courts that it could review, and they are distinct claims. In addition to the arguments I've made on the district court's expansion, in our view, of the record of the claims, we've already addressed the procedural default on the ground that Mr. Moore failed to present it to the Appellate Court of Maryland in his application for leave to appeal. But in addition to that, Mr. Moore waived the issue in the state circuit court on remand when the case came back down the first time, after the parties agreed that the ECU chain of custody was in fact admitted into evidence at trial. Trial counsel told the state post-conviction court that I think that should cause the denial of the Brady issue. And the post-conviction court agreed, and ultimately the claim was waived because he invited the outcome that the post-conviction court ultimately provided, and the Maryland courts would not review an invited error on appeal. So we argued that.
I think opposing counsel is going to probably make the argument that you all didn't raise that it was waived because you didn't raise it below before the district court.
The cases that my friend on the other side cites are from cases in which the state did not raise any procedural default argument at all. We raised the procedural default argument, and we made this argument, albeit in a footnote. It was in our papers below, and therefore the district court should not have ignored the issue and granted relief.
All right, thank you.
Thank you, Your Honors.
Mr. Patel?
Good morning, Your Honors. I'd first like to start with the procedural arguments, then I'll get to the merits, and hopefully battle it out with Judge Niemeyer. But first, I just wanted to start with the Folks issue. So the district court did not cross the line here between jurist and advocate, because here the district court did not sua sponte add the Brady claim and require briefing on it. Rather, the court merely appointed counsel to explore the Brady issue, i.e. to perhaps reframe the ineffective assistance of counsel issue into a Brady claim upon following the appropriate processes. So all the court was saying here, and clearly said this, is that if counsel, upon expiration, thought that there was a meritorious issue to add, then counsel had to file a motion to amend and convince the court that it was appropriate to amend the motion, the pro se petition. So it was counsel then who moved to amend the petition, not the court itself. The court didn't sua sponte amend the petition, and that's why this case is very different from Folks versus Nelson.
Don't you think the district court invited the lawyer to basically make the Brady argument seemed to me that the lawyer would have to be pretty dense if he didn't raise that,
Well, Your Honor, we have
based
to,
on what the district court said.
we have to take the district court at its word, and what it said is to the extent that a reframing of the petition is necessary for the Brady issue to be properly before the court, petitioner's brief should be accompanied by an appropriate motion. So yes, the court said, explore this issue. I think it may have merit, but that's very different from adding the claim itself and
that's
saying you
already-
have to brief the issue.
That's already after it already recognized that the only issue raised was the ineffective assistance, and that was without merit, and that the Brady claim had not been raised. It acknowledged that in its opinion.
Your
And
Hon-
then it basically had that clause you just said, invited counsel to.
Your
brief.
Honor, so we have to take the district court at its word.
Yeah.
I think the state wants to assume that that the district court acted in bad faith. It specifically
Well,
said.
not bad faith. It basically said that the habeas petition as filed is unsustainable.
Your
It
Honor,
denied it, right?
the court affirmatively said ground 5, the IAC claim, quote, requires further review. And then the court appointed counsel specifically quoting for the limited purpose of assisting more in further briefing and perhaps reframing ground 5. And then, again, it said to the extent that a reframing is necessary, counsel must amend the motion. So the court clearly said, yes, it was leaning against counsel on the ineffective assistance of counsel claim, but it did not decide the issue. Your Honor, it's often the case in district court, we'll be at a hearing and the judge says, look, I'm leaning against doing this, but there's not a decision until the decision comes out, Your Honor, until it is issued. Because if that were true, then if we appealed before the final decision, the state would be saying, oh, it's not appealable, because the state didn't actually, or the district court didn't actually issue the decision. But in any event, Your Honor, even if the court did decide the IAC issue, still, the court didn't sua sponte add the Brady issue. The court said to the extent, counsel, that you think that the Brady issue is meritorious to add, then you have to follow the appropriate processes. And that's very different from Folks versus Nelson, where unlike that here, the court did not counsel to explore an issue not raised in the petition, and didn't say perhaps reframe the issue, and didn't suggest that perhaps you should file a motion to amend to the extent that counsel believes that an issue is meritorious. Instead, the court sua sponte required mandated briefing on 7 different issues that were not included in the petition. So the court sua sponte there added the issue. It sua sponte effectively amended the petition. Your Honor, moving on to procedural default. To begin, Your Honor, the state argues that Mr. Moore procedurally defaulted his Brady claim in the state post-conviction court when counsel suggested at the last post-conviction hearing that the Brady issue doesn't have merit. But that cannot work here. It is well settled under Supreme Court law, Harris versus Reed, that when the state post-conviction court decides an issue on the merits, then only if the court clearly and expressly, quote, states that its judgment rests on a state procedural bar, only then can there be procedural default. And here, the state post-conviction court didn't say a word about any type of procedural bar, invited error or otherwise. So, Your Honor, in our briefs, we note the reason why the
Well, how would it
state...
say it if it was not presented to the court?
It was presented to the court, Your Honor, and the court decided the issue. But so this statement, the court must clearly and expressly state that its judgment rests on a state procedural bar. That didn't happen here. The court never said, because the error was invited, I'm not going to decide it. The court did decide the issue and didn't invoke the procedural bar. And this is a very bright line rule in Harris versus Reed. There, in fact, the court even identified, the district court identified that the procedural bar, that counsel could have brought an ineffective assistance of counsel claim on appeal and didn't. But the Supreme Court still said that there was no procedural default because the court didn't make clear that it rested its judgment on that procedural bar. So, Your Honor, in addition to the state procedurally defaulting the claim, this plain statement rule, that is what it's called, makes absolutely clear there's no procedural default in state post-conviction court. Additionally, Your Honor, Mr. Moore also preserved the issue in his application for leave to appeal. And now we have to consider that pro se proceedings must be construed liberally. In Maryland, because prisoners are not trained in the law, then imprecise language, vague language should not be an excuse not to give full consideration to the complaint. And as Judge Berner pointed out, it's clear that when the issue raised by a litigant, even one who is not pro se, is sufficiently interrelated with another issue not raised, then the court will treat them both as if they were raised by the litigant. That is black letter law. So applying these principles here, Mr. Moore sufficiently raised his Brady claim. So in the application for leave to appeal, as Judge Benjamin pointed out on page J35, it has a heading that says allegations of error, and then under that, Mr. Moore specifically states the Brady claim. Did the state commit a Brady violation? Before even getting into anything else, that in and of itself preserves the Brady claim. Now, the state says that Mr. Moore was just listing the errors that he had asserted in the post-conviction court below here, but that can't be right. The reason that can't be right is because the errors raised in the post-conviction court below were different in substance and number. If you go to page JA365, there were 6 issues that were raised in the post-conviction court below, and also number 2, in the application for leave to appeal, that issue wasn't raised in the post-conviction court below. So, Your Honors, page J35 is asserting the errors on appeal, and specifically, Mr. Moore says, did the state commit a Brady violation? So that in and of itself
The heading
tells
says
us.
that he's answering allegations of error raised on post-conviction. And he lists them there, and then the next page, it asks for reasons that the circuit court erred from denying applications, and he doesn't address the Brady.
So, Your Honor, 2 things. First of all, he writes in allegations of error. He's asserting the allegations of error on appeal for the reasons I just gave the court, because the errors on post-conviction court below were different in substance and number. Yes,
Well,
on the
maybe in
first,
substance and number, but
and in substance. So on the first page, Judge Niemeyer, it
I don't
says.
think that's an excuse for, in other words, when he says, below I raised Brady, and then the next page, he's told to say what his reasons for appeal are, and he doesn't raise Brady.
But Your Honor, he's not doing that, because the first page, yes, the statement, it says statement of facts, and it says list the allegations of error raised on post-conviction. He leaves that blank. He doesn't fill that out.
Leave it blank. He answers it.
He does leave it blank, Your Honor. Look on page J134. It's blank.
Well,
So-
that's not blank, it continues at the top of the next page.
No, but that's the point. He writes in allegations of error, and then because these are not the same as the claims that he raised.
Well, it asks, the question says allegations of error raised in post-conviction.
Right, but he doesn't fill that.
And so he then writes allegations of error.
No, but that he's asserting on appeal. The reason we know that is because these are not the same as the ones he raised on post-conviction. So he's chosen the ones that he wants to assert on appeal. In any event, Your Honor, also, the next page, the reasons for the error, he raises issues that are interrelated with the Brady claim. So even based on that alone, Your Honor, he's preserved the Brady issue.
Which one are you referring to?
So he raises the ineffective assistance of
I know,
counsel.
which number?
That's number 3, Your Honor.
All right.
Yeah, so there he raises ineffective assistance of counsel based on the same facts, based on the ECU report. And Your Honor, those issues, as Judge Berner was pointing out, are really 2 sides of the same coin. Because if the state disclosed the form in sufficient time for counsel to make effective use of it, and counsel didn't do so, then there's an ineffective assistance of counsel problem, but there's not a Brady problem. But on the other hand, if the state did not disclose the form in sufficient time for counsel to make effective use of it, then you don't have an ineffective assistive counsel problem, but you have a Brady problem. So they're completely interrelated and actually even intertwined because they are two sides of the same coin. Additionally, Your Honor, if you look to the last issue on number 4, there, Mr. Moore asserts that the state post-conviction court erred by not giving him copies of the ECU report that were in the state court file and in the state prosecutor's file, and he says that hampered his ability to investigate the Brady claim. So again, that of course is related to the Brady claim that he's raising here, and so for those reasons, he did not procedurally default in the application for leave to appeal either. And Your Honor, that brings me to the merits of the case. So this court, the district court correctly found that the state post-conviction court unreasonably applied Brady to conclude that the ECU chain of custody form was not suppressed. So starting first with that with suppression, Your Honors, the state post-conviction court's decision was unreasonable because the state disclosed the ECU form too late in time for counsel to reasonably make effective use of it. Indeed, as the state post-conviction court itself acknowledged, it was too difficult for trial counsel to exhibit the mind and capacity to spot the document's impeachment value mid-trial, mid-testimony, when counsel's focus had been on a completely different issue that had nothing to do with undermining the credibility of the chemist. Indeed, Your Honors, it would have required too much of counsel to, on the fly, examine multiple pages with multiple
I
entries.
must say, in preparation for this hearing, it took me about 5 minutes.
Well, if I could continue, Your Honor, so it would have not only required examining them in small typewritten words in the ECU form, and then the counsel would have had to compare it to the laboratory form, which also had multiple entries, and then counsel would have had to ascertain the discrepancy between the two, all when counsel's mindset at the time was on a completely different theory that had nothing to do with the ECU form. And then on top of that, Your Honor—
What if we were to conclude there's no discrepancy?
If there's no discrepancy, Your Honor, if there was no discrepancy and there was no basis to, question that the chemist ever tested drugs, yes, then we would lose. But I'm going to get to materiality too, Your Honor, and there is a very, very reasonable reason to question whether or not the chemist actually retrieved the drugs, because there is good cause to believe there's discrepancy, Your Honor, between the documents. And I'll get to that in a minute, but I first wanted to just finish up with the suppression. So, Your Honor, even if counsel was reasonably able to identify the discrepancy, it was still too late because counsel would have had to then investigate the discrepancy and look into the previous conduct of the chemist to determine whether there was any previous dishonesty in the background, and counsel was deprived of the opportunity to do that because of the late disclosure. And on top of that, then counsel would have had to figure out whether to add an alternative theory or change the theory of the defense altogether mid-trial, and then figure out whether to call the chemist to exploit the inconsistency or whether to just impeach the chemist through Detective Surratt's testimony. So, Your Honor, even if despite all of this, let's say that Judge Niemeyer was right and counsel was reasonably able to assess the impeachment value of the ECU form, there's still a problem here because it was mid-trial that counsel would have had to shift gears and all of a sudden argue a different theory of the defense. That would have undermined the credibility of the defense mid-trial, because at that point it would have looked like counsel was just throwing anything and everything at the wall, hoping that something sticks. So, Your Honor, without knowledge of the document pre-trial, it is simply not reasonable to conclude that the counsel could have made effective use of the document. Also, Your Honor, one other point I wanted to make here is that counsel says that, the state says that there was an hour lunch break in which counsel could have learned and figured out what to do with the form. But there's 3 reasons why that argument doesn't work either. Because again, by the time that the form was revealed, counsel's theory of the defense had well set in, that Mr. Moore never possessed the alleged drug. So with that mindset, impeachment of the chemist was reasonably not on counsel's radar. So considering that it's unreasonable then to expect counsel on the fly to have spotted the problem with the form, particularly when it was unrelated to the defense of the theory at the time. And second, Your Honor, even if it was reasonably able to spot the impeachment value of the ECU form, there was still time needed to investigate the discrepancy as to what were the procedures in the evidence control unit, what was the practice there, what was required to be included on the form or not, and to investigate any previous misconduct in the chemist's background. All of that couldn't have been done in an hour. And then, as I said earlier, counsel would have been forced to change his theory in the middle of trial. So there was just too much going on, Your Honor.
Why is there a reasonable probability that if the second report had been disclosed earlier, the outcome would have been different?
Okay, so yes, Your Honor, I think that there's very much a probability that the outcome would have been different. Now, before you answering your question, Judge Berner, I just wanted to say that the materiality standard is not demanding. Mr. Moore doesn't have to show by preponderance of the evidence that there would have been acquittal, or more likely than not that there would have been acquittal. All we have to show is that the ECU form reasonably cast the case in a different light so as to undermine confidence in the outcome of the verdict. And it did so, Your Honor, because 2 reasons. So there's 2 important pieces of information here that went unrefuted. The state did not put on any evidence to refute them. First was the notation on the ECU form itself, which said that it documented all transactions that occur on the item. It didn't say that that document only documents transactions that occurred in the evidence control unit itself. And Your Honor, it's not only that. We also had Detective Surratt's testimony after that, where Detective Surratt, quote, said the form documents every time somebody takes custody of the narcotic from when it is received to when it is submitted. Now, the detective did not qualify that by saying that the ECU form only documents movements within the evidence control unit itself.
Let me just take you, I mean, your time's running out, but here, I'm looking at page 334, 335, and 336.
Yes.
334 is the chain of custody in the evidence control unit. It says on November 4th, the evidence was checked out and given to the lab. You go to the lab and it says about 10 minutes later, on November 4th, it was received. Then it says, while it's in the lab, then it goes into the vault, received into the vault, and then it's checked out in the lab. Let's see, where's it checked out? On the 9th to Barry Berger. He's the guy that tested it. Then it goes back in about an hour later, and then it checks out on December 10 back to the evidence room. And then you go back to the other one, it says December 10th, received in the evidence room. It's just an exact fit. In other words, the evidence control room has checked out to the lab on November 4th and received from the lab December 10th. So there's a gap there. It goes to the lab December on 4th and the 10th. So you go to the lab and it shows received on the 4th and sent back to the unit on the 10th. And while it's in the lab, they have entries for when it was taken out and tested and put back in the vault. And it is just minute for minute, and it has the person who did it, the badge number, the signature of the person. I just don't see a discrepancy.
So, Your Honor, there is a discrepancy. At least there's a reasonable basis to question whether or not the evidence was retrieved by the chemist and tested, because we have to accept what the chain of custody ECU form says. It says the following is a chronological list of all transactions performed on this item. And then when you
All right, so let's take the
What-
November 4th, it goes out, right?
But this is on the form, ECU, it's not on the
I
ECU
understand.
form.
Now, we're
It's
on the
not
ECU,
these.
we're on the ECU form, and this is what he has at trial.
Sure.
And it shows checked out from the evidence room on November 4, right?
Yes.
All right. The next entry is December 10, and it says received from the lab on December 10.
Right, but what's missing there? Missing there is, there's nothing
It's at the lab.
documenting. It's not, but it's not, this says that
This is
all.
the evidence, it says the evidence custody unit checks it out to the lab. And then they receive it back from the lab on the 10th.
But Your Honor, this form says all transactions, whether in the ECU unit or otherwise, that's how we have to interpret it, because it doesn't limit it to
No, but
movements in
point
the evidence
is that
control
when
unit
the two
form
documents
itself.
were later examined, both you and the district court contend there's some tension between the two.
There are.
And
The-
I respectfully disagree. I think it's actually as plain as day. I mean, if I were interpreting these two documents, I can give you minutes, and the only discrepancy is about 5 or 10 minutes between each transfer when they go from the lab back to the
Well, Your
unit.
Honor, if it was so clear that the evidence, this
Well, I just
ECU.
traced it through. I've got the-
If it was so clear that the ECU form only recorded transactions that occurred within the evidence control unit itself, then.
No, it doesn't matter. That's irrelevant, because the unit itself says, we transferred it out to the lab.
Yeah, but the
And
question
it
is
does not
what has
purport
to.
to, it's been in the lab the whole time, and it comes back. So that's all accurate.
But the question is, what has to be included on the form? And this form is telling us, anytime there's movement in the laboratory
Doesn't
or
say
in
that.
the evidence,
This
that's
is
what
an
it's
ECU
saying.
document.
It says the following is a chronological list of all transactions performed on the item. And then we have Detective Surratt who said that. And Your Honor, if it was so clear that this form only documented transactions that
No, I'm not saying it only
occurred.
documented. I'm saying the problem is, later, when we're analyzing this under habeas, we have both documents. And the only basis for the district court saying impeachment could have occurred is because the two documents were inconsistent. And the two documents are just simply not inconsistent.
Your Honor, by the way, I just wanted to correct, that this is habeas, but if this court finds that the evidence was, that the state post-conviction court unreasonably found that the ECU form was not suppressed, then we're on de novo.
No,
And so materiality is to be considered de novo.
We have a district court that decided it was presented with an ineffective assistance of counsel, including how to handle that document. The court concluded the counsel was not ineffective. Then the court said, but there may be a Brady violation because of the difficulty between the two documents.
And it wasn't just
And
that.
that is where the court was a volunteer and went out.
It's not just the district court, the state post-conviction court also found that
They
there
didn't
was a
have the two documents,
discrepancy
did
and
they?
that it was material.
Did they
So
have
we
two-
have two courts now who have found that there's,
Did the state court have both documents?
the state court did. In the state post-conviction court, in the last opinion, the court continued to say that it was material and adopted.
No, my question to you is, did the state post-conviction court have both documents, the lab document and the
Yes.
evidence room? They had them both.
Yes, they had them both, Your Honor,
Okay,
and there
okay.
was a
Well,
discrepancy.
that's all the worse. I mean, the
Between-
question is, why are we fighting procedurally over this long process and ordering a new trial over the fact that two documents which are read together are just clearly create the chain of custody? There is no impeachable evidence here. And that the question is, we're sending it back for a new trial to determine these two documents cause a new trial? That's what you're arguing.
Your Honor, I respectfully disagree. The state had every opportunity. There were four post-conviction hearings here to
Well, that's procedural,
establish.
but we're now,
to
we have
establish-
hindsight. We have hindsight right now. We're sitting here as an appellate court, and the issue before us is, should this case be retried based on hindsight now?
And that's what happens when there's a Brady violation, Your Honor. And
If there's
Brady
a Brady,
again,
there's not a Brady violation. There's nothing inculpatory or impeachable here. The question, objectively, nothing impeachable. You cannot tell this
Your
man.
Honor,
Yeah.
if one document that's Detective Surratt said must include all transactions, and then on the ECU form itself, it says it must include all transactions, not just limited to one place, the evidence control unit, and we don't see any entry from the chemist
Sure you do.
indicating that he, but that's on a different document. That's
It's-
not on this
It's on the
document.
chain of custody. In
It's
other
on a-
words, the chain
on a
of custody
separate
in this.
document.
You-
Also, Your Honor, I think it's important to point out here too that if you look to the laboratory form, the laboratory form has some overlap with the ECU form. The state keeps saying that they're two separate documents. One documents all the transactions that occurred in the ECU unit, and the other documents the transactions that occurred in the laboratory. But they're not as separate as the state says they are, Your Honor, because even in the laboratory form, there's transactions recorded that occurred in the evidence control unit. So why wouldn't the same apply to the evidence control unit then? If you look at the first line, it says ECU, Officer Ronald J. Surratt. This records the time that he took the evidence to the evidence control unit, yet it appears on the laboratory form. So, Your Honor, it makes sense that the evidence control unit form would
Well, that's
also
even more-
indicate all entries.
That's more indicative of the fact you have to read the two forms, because this lab form covers only the time from November 4, in the lab, from November 4 to December 10.
It doesn't. It also has 1103, the
That's-
first entry.
Yeah, but that refers to the evidence room.
Well, that's my
And
point.
he's sitting there documenting on the fact that the evidence room has it. Now, the next line says when the lab received it. I mean, it's just not, I don't know what you're making a
Yeah.
fuss out of, something that's just not confusing.
Your Honor, two courts thought that there was something to make out of this. That-
That's
I mean, and
because
Judge
what you
Bernard's
said
a very,
about it.
Judge Bernard's a very smart judge, as you know, Niemeyer. He has your intellect, so.
I agree, he's a very smart judge. He's a very good judge, too.
Yes, absolutely.
And you're a good lawyer.
So,
All right, we're way over time
Okay.
here, we understand. And,
great, thank you.
all right, Mr. DiMaselli?
Thank you, Your Honors. I'll be brief. I just want to briefly address Judge Berner's question about the Unger case. I don't have the full opinion before me, Your Honor, I apologize for that, but on page 17 of our reply brief, footnote 9, I cite inextricably intertwined with one another. That's the Unger case, 427 Maryland at 407 and 408. So I think that the Unger court did discuss inextricably intertwined with respect to claims that have to be raised. The second issue I want to point the court to with
Let me ask you a question, just based on the previous exchange. So when the the drugs are transferred to the lab, right? The ECU form is attached to the I guess Ziploc bag or whatever containing the drugs.
I don't think the record makes that clear. I'm not sure that it is. So there's one kind of curious aspect to this case, which is the chain of custody from the ECU in this case is dated after the trial happened. So I think that, as we pointed out in our reply brief, this is an electronically generated document. I don't believe it travels with the evidence. And in fact, there's no physical signatures on here. So it would make no sense that it would travel with the evidence. And the same thing goes for the laboratory form. Yes, there are sort of cursive signatures, but you'll look, they're identical. These are electronically generated signatures on an electronically generated form. These forms are separate. They don't follow the evidence around like in the days of old where they would sign off everywhere it goes. So these are not inconsistent. And to sort of respond briefly to my colleague's point, it does say all transactions, but this is the ECU form, this is the evidence control unit form. It never says that this form is intended to follow the evidence around and log transactions at a different location. And at both the state
It
post-conviction.
doesn't cover any custody from the officer bringing it in. I mean, the officer obtained it out in the field. They found the evidence had been disposed of, and that he had it in his vehicle, I'm sure, and brought it in, and so it doesn't cover that.
Right.
And it doesn't cover what happened after it, after the last entry. I mean, it's a...
Yeah, and I also point out to the court, if this was intended to log all transactions, what is the purpose of this laboratory form? Why does it even exist? Well, the answer is, I think, clear, because this is the ECU and this is the laboratory, and they don't necessarily track the logging of evidence at their respective location.
Well, what about his argument that the lab report does track, is tracking the ECU logging?
I think it's logging who initially brought the evidence in. For their purposes, I'm guessing that they want to know who was the officer who brought this in the first place, and where did the drugs go when it got back to the ECU? And then it stops, right?
But the first entry basically says ECU. The guy put it in the
Yeah.
ECU.
Yeah.
So it's not at the lab.
It's coming from the ECU, and this was the officer who initially brought it there. And then this is the laboratory. This is the Barry Berger is on there, and then it goes back to the ECU. And the documents
But
are
it
not
goes to him, it
inconsistent.
goes to him just for an hour, I think, to examine it.
I think it was just about an hour.
Yeah.
Yeah, which is entirely
And
consistent
he
with,
checked it out and then checked it in.
I don't think that there's anything here. Certainly, the defense could have called in the chemist.
I know, but
and-
regardless of what could have happened.
Yeah.
What we're now trying to determine as an objective matter, whether this was Giglio type of evidence, Brady. And my suggestion is that when I look at this, I don't see how we have anything that even had to be disclosed unless it was under some relevant standard. There's nothing here that's exculpatory.
I agree.
It just basically says in and out, this is where the evidence went. The argument is because the two documents are inconsistent, therefore they were manufactured, therefore the officer was lying when he tested it. But there's nothing here to suggest that.
I agree, and I think it's far-fetched to believe that the jury would have looked at
And
these
so
two
we're gonna,
documents and
on this hypothetical that this is all false and therefore the lab guy didn't test it for that 1 hour when he took it out and put it in, and therefore it's a false made-up test, you don't get that from the document. You may get it, somebody else can say it. And so the question is, we're gonna have a whole new trial on this hindsight look at something that never exculpated anybody.
yeah, I agree. May I make one brief point?
Yes.
Just in response, I mentioned there's an hour-long lunch break during the trial. The point I really want to make is that the trial counsel had sufficient time to see what this document is, recognize that I've never seen this before, and he could have asked the court for a postponement to conduct whatever investigations he needed to in order to utilize this document. And so in terms of suppression, he had sufficient time. It wasn't like he was, we're
At
not,
the trial, did just the ECU go in? Or did they both go in?
I think it was just the ECU, to be
And
honest.
when did the lab?
The lab was disclosed in pretrial discovery.
Oh, in pretrial.
Yeah, the laboratory form, they never raised a Brady claim with respect to the lab reform. They had that.
So they had that.
They had the lab form, yes.
So they just got the ECU form during the trial.
Right, and then, yeah. And their argument, of course, is that, he can't compare the two mid-trial on the fly. And our brief response
Well, now,
is.
the circuit court said the same thing when she reviewed it as to the ineffective assistance of counsel. She said it wasn't reasonable for counsel, and it wasn't ineffective for counsel because of the late disclosure of the document.
Right, but he could have. And I think the reason he could have is because he could have seen this form. He should have immediately recognized that this is something I've never seen before and said, I need a postponement to look into this. And then called the chemist and impeached him for whatever that was worth, which, as Your Honor and I agree, was absolutely nothing. So for these reasons,
Thank you.
yes.
We'll come down to Greek counsel and proceed on the last case. last case we'll hear this morning is Martinez versus McHenry and Mr. Russo. McHenry, what's his position?
As opposed to the former Attorney General?
Is he the attorney? He's not the Attorney General. He's the acting? Acting?
Yes, I just got the
I
document.
know, it's just a formality, but still. I was trying to figure where somebody was confirmed, but I think Bondi is nominated, right? Ms. Bondi for Attorney General?
Yes.
Yeah. Garland would be the normal.
Yes, it was Garland up until yesterday, as
yeah,
per the
All right.
court's docket.
That's just an irrelevancy. I just wanted, okay. All right. Mr. Russo,
Good
go ahead.
morning, may it please the court. My name is James Russo, and I represent the petitioner, Mr. Martinez. In this matter, there are two key issues for this court to review. First, whether the board erred in denying Mr. Martinez's motion for remand for consideration of cancellation of removal. Second, whether Mr. Martinez established the requisite nexus to a family-based protected ground. I'd like to start with the motion to remand issue. In 1988, the Supreme Court explained very instructively that an applicant needs only show a prima facie case for relief when seeking reopening or remand. And you would think that a term such as a prima facie case, something we all learned our very first years of law school, would not be as equivocated and is subject to disagreement as it has been in this case and other cases that I've seen before the
Well,
agency.
wouldn't that be a precondition? But that doesn't mean that governs the discretion, does it?
It is a,
Your argument suggests that if there was a prima facie case, they have to reopen?
absolutely not, Your Honor.
Okay.
My position is that if the statutory elements are satisfied, which is what Abdu states is necessary, and in this case, for cancellation of removal, it's those four elements in INA 240AB1, continuous physical presence, good moral character, exceptional and extremely unusual hardship to a qualifying relative. Those are the elements. After those are established, you need to show then you warrant additional fact-finding for that form of relief. It doesn't require that an immigration judge would definitely or absolutely grant or guarantee that a meritorious showing be made. And that is what the board is essentially saying in this case when it abuses
So what level of proof is required at that stage, if any,
after the statutory elements are shown.
regarding the discretionary prong?
The discretionary prong is not something that must be demonstrated through a motion to remand, because that is something that is a intensive fact inquiry that requires a balancing of
But
equities.
do there need to be facts alleged, at least, in the motion to remand that would satisfy the discretionary aspect of the test?
No, Your Honor, because in this case, the crimes that are stated as failed to have been addressed, as the board states here, the respondent is unable to address those because he can't testify regarding the circumstances of those crimes. Matter of Mendez-Morales says that taking responsibility for one's past transgressions is evidence of rehabilitation. And evidence of rehabilitation is a positive equity which must be balanced against those adverse factors, but we
Well,
can't.
he could have responded to the, I mean, it sounds like what the BIA was concerned about was the 2016 charge for being drunk in public, which your client, I think, paid a fine and accepted a plea. Is that what happened?
Yes, Your Honor, but
And so that wasn't even addressed in the request to remand.
But if it is not a good moral character bar under INA 101F3 or a statutorily barred offense under 237A2, which is, I believe, the third requirement for cancellation removal, as I'm seeing the statute in my head.
You got it.
Those, I'm sorry, I lost my train of thought.
I was
BIA
asking
did
about
not-
being drunk in public charge. The BIA seemed to be stuck on the fact that he didn't address it.
Yes. Well, if the crime at issue is not going to bar him outright, and it's not going to be something that is going to prohibit a good moral character finding for the 10 years of required continuous physical presence, then it then becomes a balancing test between the adverse factors and the equities, something that is inherently fact-intensive, which is reserved for the immigration judge. And that is stated in 8 CFR 1003.1D3. The BIA is constrained expressly from engaging in such a fact-intensive inquiry because the respondent is unable to demonstrate any of the equities or testify regarding the circumstances of the crime. And those are the factors that either would lead to an outright discretionary grant or not after the statutory elements have been established. The statutory elements, once established, need show that further fact-finding is warranted. And the Supreme Court equated a motion to remand as, in the criminal sense, a motion for a new trial, where fact-finding is not only warranted but necessary based on the issues that are still to be determined, but at the appellate level for the board to not only make no finding with respect to the statutory elements, but go beyond that and state that there was no showing that favorable discretion was warranted. They, in effect, have conflated the requirements for a prima facie case and then the ultimate question of whether relief is warranted.
You say a prima facie case. Did the government answer your motion to remand
They responded.
before the BIA?
They responded with their brief before the
Yeah.
BIA. I apologize, I was not the counsel before the board, but
Did they respond?
in their
Yeah.
opposition to
Yeah.
the.
Remand.
Yes,
And what did they say?
in their response,
Yeah.
that, well, I don't recall.
Well, my whole point is you keep emphasizing this prima facie. Prima facie usually means it's sufficient without more. And if the other side answers, then you're thrown into a whole different category. Prima facie just gets you started on the motion. And since the government answered, now the question is the BIA has discretion to assess your position and their position on whether to remand.
But they don't have discretion to make a finding that favorable discretion wouldn't be warranted based on the submissions in the motion to remand. Ms. Chavez is what gave rise to this newly available form of relief. He established that he has a lawful permanent resident mother and he has a U.S. citizen child. He made a showing of the hardship that they would face should he be removed, and that he is not barred statutorily due to the nature of his convictions, and that he was a person of good moral character for 10 years. I mean, it's a continuing application, so he would have to show 10 years up until the final decision. But beyond that, whether relief is ultimately warranted in an exercise of discretion, that's a regulatory requirement, not a statutory requirement. And for the board to conflate the two is
Well, it has to forecast a little bit when exercising its discretion. In other words, the question is whether there's a futility aspect to it, a timing aspect, the use of agency resources. I mean, if it's just going to be a slam dunk against you, why would they remand it? In other words, there is always a little bit of conflation.
It's not going to be a slam dunk against either side, which is why additional fact-finding is so necessary in this case.
Of course, it'll be necessary if you got a remand, but that gate is a highly discretionary gate.
But it was the board's abuse of discretion, which we submit occurs here, which led to that erroneous denial of that motion to remand. Specifically, the board cites a regulation that is under the heading of 8 CFR that states determining removability in immigration court or in removal proceedings. That's what the title says. But that is not the procedural posture that we're at. And the board yet cites this regulation in support of its conclusion that.
Well, that's my whole point. In other words, if they look at the removability statute and they see requirements that simply could not be met, If they say, hypothetically,
What are
if they,
those
just a minute,
requirements?
if they see stuff that could not be met, why wouldn't they exercise their discretion and not remand?
They should state such. I mean, matter of coilo says that you must submit a proposed application for relief and a motion to reopen. That is instructive on how to put forth
So
a
what
motion
do
to
they
reopen.
get to
This needs-
consider? If they can't consider futility and merits of your claim on removability, what do they consider?
I'm sorry, I did not understand.
What does the BIA consider in the motion to remand?
It considers
If they-
whether
You
they're-
say they conflated the role of the IJ with their role.
It
the
considers
BIA's.
whether statutory eligibility has been established for the newly available relief.
Or
That's what it
likely to be
considers.
established, or is it possible? In other words, what factors is the board entitled to consider on remand?
Whether the relief is been prima facie made. If
Yeah,
you-
but prima facie just gets you in the front door. Now the prima facie allegations you make have been answered by the government. So now the analysis has to go further than just the prima facie case.
And the board is not the actor to
On the
to
motion
get
to
that determination.
remand it is, you're talking about a prima facie case for remand, right?
So they have, the board does not have plenary discretion to refuse to remand a case for further fact-finding when a showing is made that newly available relief is viable. I mean, imagine this in the adjustment of status context, where you have somebody that was lawfully admitted, acquires an immediate relative, they show that they can adjust status and acquire lawful permanent residency through that relative plus their lawful admission, and yet you're just gonna say that you haven't shown that you warrant favorable discretion, even though we're not the body that makes those findings, therefore we're gonna deny that motion to remand. There would be no further subsequent developments favorable to any respondent in removal proceedings if that were the narrow view taken by the board. And in this instance, this reasoning cannot sustain itself when you look at what's backing it. I mean, it's moreover, Senatha Mukasey, which was a Fourth Circuit case out of '08, explicitly made clear that the board may not weigh new or disputed facts de novo without a hearing. And where there is facts that would be dispositive one way or the other after statutory eligibility for newly available relief has been shown, then a new hearing is appropriate. And without an explanation beyond, you did not address this crime. What does that mean? I don't know. I mean, at least with Coilo and other factors when in regards to after a decision has been made at the immigration court level, we know what is required in order to earn a remand or to apply for additional relief. But here, nothing but ambiguity and acting outside of the role of its appellate fact-finding function.
Can I ask you a question about the procedural posture? Is this a motion to remand, or is it a motion to reopen, and does it matter?
It's a good question. Motions to remand before the Board of Immigration Appeals are evaluated and construed as motions to reopen. So they have the same standards, so to speak, or at least they are evaluated in the same way, although, of course, we are procedurally in different places when each is submitted. But for purposes of before the board, a motion to remand is evaluated just like a motion to reopen.
So it's the same standard of review for
Yes,
us?
yes, which is an
And-
abuse of discretion.
And if we were to agree with you that there was an abuse of discretion, why wouldn't we find then that error was harmless?
Because his deportation is at stake. I mean,
I understand, but he would still need to establish that exercise of discretion is warranted to grant his motion, and I see nothing, at least in his motion before the BIA, that even mentions anything about discretion. There's simply no mention of it. It's completely silent.
because the discretionary component is something that the immigration judge balances in the first instance. Matter of CVT, the board lays out all of the equities, all of the adverse factors, how to balance those, and how a discretionary determination is made with respect to cancellation of removal. If the guidance is for immigration judge to engage in this highly fact-intensive inquiry in the first instance, how is the board which is expressly precluded from doing so, supposed to do so, like, supposed to engage in that function, which I would submit is ultra vires in the first place. They are acting beyond the scope of their regulatory authority, and they're doing so with tenuous reasoning at best. Just briefly, if I can turn to the nexus question. The immigration judge and the board incorrectly concluded that Mr. Martinez's dispute with his persecutor was wholly personal. And this has been an issue I have raised before this court. I think I even submitted on the docket, similarly situated cases. It was active at the time. But this court's decision in Velasquez v. Sessions has well exceeded the scope of what I would submit this court and even the panel in Velasquez would have ever intended, because Velasquez involved a purely personal, intra-family custody dispute between an aunt and a mother over a child. This is a land dispute which not recognized expressly by this circuit, but is a protected ground, or I apologize, an immutable characteristic in and of itself, recognized some as the sufficient basis for a particular social group. And they've essentially said, well, no, if there's any personal element whatsoever, we are going to wholly reject the cognizability of that nexus to a protected ground, even where there is sufficient evidence to show that this 12-year-old was threatened, and that is in his relationship to his mother and his inheritance interest in that land is why he and not someone else was targeted. This court has utilized a very instructive doctrine time and time again, admonishing the board on refusing to consider mixed motives and interrelated and intertwined to draw from our practices reasons, and as long as one of those is essential, the nexus can be found. And I would point to a Sixth Circuit case that states that if there is a nexus between the persecuted if there is a nexus between persecution and a membership in a particular social group, the simultaneous existence of a personal dispute does not eliminate that nexus. And I would ask that this court to join the Sixth Circuit in rejecting this monolithic causation approach, which has expanded its scope over the years since Velasquez's publication. It's no longer about intra-family or purely personal. It's looking for one personal modicum of circumstance as it pertains to that claim, and it's using it as a backdoor to reject it outright. And that is not what this court has instructed in all its subsequent case law regarding mixed motives.
So what's that evidence is in the record your claim is in it regarding some nexus? What would be sufficient evidence? Other than something that happened when he was 12 years old?
It's familiar ties to his mother, that's the, I would actually point to Tortilla Flores, which pointed out,
just to get down to the particulars, that the threat to him is not based on his relationship to his mother, but based on his mother's dispute over ownership of the house. And, I mean, I understand, but that's what they found as fact.
the often repeated IIA errors this court read Vasquez, incorrectly placing why a person targeted a petitioner's family, not why they targeted a petitioner himself. Even though this court only tacitly has endorsed approaches of First, Second, Seventh, and they guys quoted they were in Ninth Circuit in evaluating persecution from a child's perspective in that moment. Okay, so if you don't have a death threat per se, as it would be interpreted by an adult, how's it wrong to interpret this dispute as is happening? That's the past persecution that is on account of his ties to his mother, which would trigger the rebuttal of someone who knows about your persecution. All of this is lost on the board and immigration judge simply because they identify one personal element or one personal factor that this case rests on. And that is not what Velasquez sought to establish
please the court. My name is Robert Molman, representing the Attorney General. I'll start with the issue of nexus. Here, the board rightly relied on this court's decision to localize the section, which held that a purely personal dispute, which is what we have here, simply is not a protected ground and cannot be the basis for a viable asylum claim. Here we have Martinez's testimony himself that the person that he fears in Honduras was motivated solely by a personal dispute. Here it was a property dispute with Martinez's mother. This dates back some 30 plus years ago, and we have scant evidence as to what the interactions were between this Nandan individual in Honduras and Martinez here. The board relied on that decision, which controls here, and therefore the court should affirm that particular issue. Turning to the issue of cancellation of removal, petitioner did request a remand on that basis, and it was denied under the prima facie evidence. The board...
It looks like, as to his argument, it does look like the BIA gets into, it's almost as if it's some type of mixed standard of review between the discretionary relief and the prima facie case. And in my reading of it, there's no discussion of him paying taxes, being here 10 years, having a daughter here, having a mother that's ill. It seems like there's some mixing or some weird standard of review that the BIA used here on the removal as to the discretionary function.
The issue here, though, is that petitioner provided no claim that he would even merit an exercise of discretion here in granting the relief. So it would have been premature to engage in any kind of weighing of any of the factors here, because petitioner is attempting to make a prima facie case to show that he's eligible for this very rare form of relief, cancellation of removal. He didn't even say, I would merit this relief as an exercise of discretion. That's particularly noteworthy here because he has an extensive criminal history here. And cancellation of removal
He has an
is...
extensive criminal history? What is the extensive criminal history exactly?
2 DUIs.
Which are outside the statutory...
For a good moral character, but not for discretionary purposes. Also, this public intoxication offense from 2016, and he was also arrested for another matter, which I believe was dismissed.
And do any of those fall into the moral, what is the standard, good moral character consideration? I don't think any of those. There's no evidence that he was a habitual drunkard. There's no evidence that and I'm looking at the considerations, and it doesn't seem like any of those, the 2 very old DUIs, the public drunkenness misdemeanor that he, I guess, entered a plea on, none of those are part of the considerations for good moral character, are they?
Right, but good moral character is, well, for one, good moral character could involve the 2016 offense. That would have fallen within the applicable time frame, and the board notes that the 2016 offense is not even acknowledged in the request for
But wouldn't
remand.
that be for the IJ to consider? Wouldn't it been more appropriate for the board to send it back for the IJ to consider the specifics and the facts as to the 2016 public drunkenness?
It wouldn't be here because it's not even addressed, so there is no prima facie case here. And there are 2 different issues here, just to clarify. The good moral character is a different issue than the discretionary determination. The discretionary determination, anything can be considered, not anything, I suppose, but more or less anything. So any of these crimes, despite
Right,
them
but what
being
you're calling
older,
is
could
saying
have
that's
been
not for the
addressed.
BIA to determine the discretionary prong, that's for the IJ. So in terms of the aspects that are properly before the BIA, I mean, I'm looking at the prongs for good moral character, and I don't see any of them that would actually fit for the 2016 charge.
Well, for one, the discretionary determination is something that needs to be addressed as a prima facie case. That's in an attempt to make a prima facie claim for it. That's matter of Chen. That's a board decision where a attempt similar to here to remand, to reopen for consideration of cancellation removal was denied.
Matter of Chen isn't binding on us, is it?
No, it's not, but this is a board procedure and this was in front of the board, and the board was following its own procedures as set forth in matter of Chen. And
What's your understanding of the procedure? I questioned your colleague on this and pressed him a little bit, but it's not altogether clear. What he's required to do is to put forth a prima facie case before the board. I gather the prima facie case would be a prima facie case for the relief that the IJ would grant. Is that it?
correct, presumably, yes.
And are there any other factors that he would have to allege to inform the BIA's discretion to remand? In other words, is the BIA's discretion informed entirely by the strength of the prima facie case, or is it informed by other matters?
It can be informed by any matter. So it has discretion to simply deny even if the prima facie evidence is put forward. So the denial here, any error, even if the court was to find one, would be moot here because the board could have denied just as an exercise of its discretion, even if there was an assumption that prima facie evidence,
But
prima
that's not
facie
what the
case was
board
made.
said it was doing. It said it was denying because the petitioner had failed to meet a burden to establish a prima facie, or to plead a prima facie case. It didn't say it was exercising discretion.
Correct. I'm saying this would be
It
a
could
harmless
have,
error
but it
for that
didn't.
reason.
And it didn't say in the alternative, it could have, but it didn't.
Correct, but it also did say, under matter of Chen, that he did not put forth any evidence to address, even in a prima facie matter, the issue of discretion. There's two issues of discretion. One is the board's discretion to deny a motion such as this, even if a prima facie case is made. And the second is, in order to make out a prima facie case, you have to address whether you merit the underlying relief as an exercise of discretion. Here, the petitioner didn't address either issue, didn't address these particular concerns that are naturally concerns in this case. No, we're not address that specifically, no. But here, again, this is a very rare form of relief. That's why the discretion is particularly important. Nearly 4,000 cancellation removal claims can be granted per year. So this is a very extraordinary form of relief. That's why someone with criminal history needs to address that in some way, just to make a prima facie here. Having done that, not at all, it's critical.
That's not one of the factors in the statute. It doesn't say that. It says,
It's a discretionary factor, so it can be considered under a discretionary.
you know, and it's interesting, in my alliance and Chen is because Chen was on methodology, and then methodology is the opposite of Chen, which says, in fact, in consideration of reopen, the board should not prejudge the merits of a case before the alien has an opportunity to prove the case. Deciding that there's a reasonable likelihood that the statutory requirements for relief sought is satisfied, and there's a reasonable likelihood that relief will be granted in the exercise of discretion. That's what it says. It doesn't say that at the remand stage. And I see that at Chen. It's interesting. Chen is relying on methodology for a proposition which actually doesn't stand for.
Here, there's no way to have established a reasonable likelihood of success in an issue of compound discretion, and discretion is not addressed whatsoever.
The board seems to think that methodology that it's the IJ that needs to exercise that discretion.
Perhaps that exercise discretion would have been eventually given to the relationship you had a prima facie of a case being made as to that point, but there was absolutely nothing to address on that issue.
You're saying that exercise discretion is part of a prima facie case.
Correct. No, the board is no further questions. Yes, the board's not. Thank you.
personal nature. That's exactly what the Sixth Circuit case dealt with. It had forced marriage on their basis and it had loans in those areas. The Sixth Circuit nevertheless found that Ohio's access to a family-based particular social group could be found. And I would ask the court to thank you so much for this.
Adjourn the court for the day and move down to Greek Council.
This honorable court stands adjourned until tomorrow morning, God willing,